gracious greetings to the bench, Honorable Mr. Justice Ajay Mohan Goyal sir, Honorable Mr. Justice Sushil Kukreja sir, and Honorable Mr. Justice Romesh Verma sir, thanks for accepting our invitation and gracing us with your presence. We also have with us Professor Dr. Rejoinder sir, who is Vice Chancellor, Maharashtra National Law University, Nagpur. We welcome you, sir. We also have with us Shri Piyush Verma, sir, who is the President of the HP High Court Bar Association. We welcome the entire cabinet and also the honorable judges. To begin with, I request Honorable Vice Chancellor, Madam Professor Dr. Preeti Saxena, to welcome the dignitaries with mementos, shawl, cap, the traditional Himachal representation, that is the Ran Singha. Ma'am, to begin with, Honorable Mr. Justice Ajay Mohan Goyal sir. Sir, we welcome you and thank you for next in order, Honorable Mr. Justice Sushil Kukreja sir. Sir, we thank you for your presence and accepting our invitation. Honorable Mr. Justice Sushil Kukreja sir. Next in order, Honorable Mr. Justice Romesh Verma. Sir, we thank you for accepting our invitation. Next in order, Professor Dr. Vijender Kumar sir, Vice Chancellor, Maharashtra National University, Nagpur. Thank you for accepting our invitation, sir. And finally, in order, Shri Piyush Verma sir, Senior Advocate and President of Himachal Pradesh High Court Bar Association. So, with that felicitation and on that note, and with the permission of the honorable judges, may we begin with the final round of the 6th HPNLU National Moot Court competition, organized by HPNLU Shimla in collaboration with National Human Rights Commission. Over to the honorable bench.
Good morning, everyone. I, Petitioner, greet you on behalf of the Moot Court Committee SPNLU Shimla. I will be the court master for this round. And we have TC 658 as the petitioners and TC 672 as the respondent. I will speaker number 1 from both the teams to apprise you with the time division between both the speakers of your respective teams.
Speaker 1 will be taking 20 minutes, 25 minutes for speaker 2, and we reserve 5 minutes.
Thank you.
For TC 672, speaker 1 21 minutes, speaker 2 26, reserving 3 minutes for service.
All the participants are requested to maintain the decorum vote. With the permission of the judges, I request the teams representing the petitioner side to begin with the competition. Best of luck to both the teams. I have a discussion to be.
Proceedings of the day may please the bench. The counsel for the petitioner in the case of Mr. Rejoinder versus the Republic of India humbly seeks the permission to collectively address the bench, Your Honor. Much appreciated. Your Honor, I, counsel 1, shall be dealing with the first and second contention, and my learned co-counsel shall be dealing with the third, fourth, and fifth contention, and we shall be taking 20 and 25 minutes respectively of the honorable bench. Your Honor, before we begin, we have placed 2 flags of podium before the bench for the convenience, as both the counsels will be making their speeches. If Your Honor is satisfied, the counsel seeks permission to briefly state the facts. Much appreciated. Your Honor, the case arises in the Republic of India, where writing insurgent activities in the border state of Gujarat compelled the government to launch Operation Kumkum, a cross-border military threat which the state claimed to be a strategic success. However, local practically humanitarian groups alleged civilian deaths, village destructions, and displacement. An independent journalist who is the petitioner in the pertinent matter received drone footages from a tribal leader and posted them on social media, accusing the government of hiding civilian casualties and violating international humanitarian law. The government dismissed the claims as misinformation in a press release and protest followed. During one protest, the petitioner attempted self-demolition outside the district commissioner's office as a symbolic act to draw the administration's attention. He was rescued and later arrested under Section 152 and 226 of Indian and relevant provisions of the Information Technology Act of 2000. He pleaded before the Honorable High Court to quash the FIR and seek interim release on bail, both of which were rejected by the Honorable High Court. This prompted a constitutional challenge before the Honorable Supreme Court questioning free speech, criminal liability, and proportionality of punishment. If Your Honor is satisfied, the counsel seeks permission to state the jurisdiction of the particular matter. Much obliged, Your Honor. Your Honor, the counsel for the petitioner in the particular matter have approved the Honorable Supreme Court of India under Article 136 of the If Your Honor is satisfied, the counsel seeks permission to proceed with the first contention. That Section 152 of Indian is unconstitutional as violative of Article 91. Your Honor, the counsel shall be dealing with the contention in a threefold manner. Firstly, Your Honor, the very first argument that the state, that is the Republic of India, is relying on is the presumption, is the protective cover of presumption of constitutionality. Your Honor, the counsel would like to highlight the fact that it is well established that legislation enjoys the presumption of constitutionality. But Your Honor, it is humbly put forth that the presumption is not irrebuttable. The counsel would like to highlight flag 5, page number 13 of the compendium that is placed before the bench. If Your Honors are with me. Flag 5, page number 13 of the compendium. If Your Honors are with me. Your Honor, it was highlighted in the case of Jindal Stainless Steel Limited versus the state of Haryana.
One question, you are invoking the jurisdiction of the court under Article 32 or 130?
Under Article 136.
Under Article 130.
Indeed.
Then which is the order which you say under Article 130?
Your Honor, the counsel for the petitioner Supreme Court under Article 136 because they have been a gross miscarriage of justice. They have been violation of fundamental rights, and Your Honor, the counsel for the petitioner is also highlighting the.
What is the difference between 136 and 55?
Your Honor, the counsel would like to highlight that
No, I'm just posing a query to you. What is the difference between Article 32
much
as compared to Article 130?
much obliged, Your Honor. Your Honor, Article 32 is particularly for the enforcement of fundamental rights. It cannot be used as an appellate review, whereas Article 136 gives a wide discretionary power to the Honorable Supreme Court and can be used as an appellate court.
So we need right that if you are invoking the jurisdiction of Article 130, you are aggrieved by some judgment passed by a court under Article 220.
Indeed, Your Honor.
So what is the judgment that is against you?
Your Honor, the order of
Because you will have to see there is a fundamental difference between filing a petition under Article 52 and Article 130.
indeed,
When you are approaching the court under Article 52, there is nothing. You don't have any bag and baggage. There is a preposition. You are attacking that preposition in terms of Article 50. But when you invoke Article 136, you have already approached the court under Article 226.
indeed, Your Honor.
And you are agreed by a judgment and therefore you are study of the court. by the High Court against which you are approaching this? Because primarily you will have to attack the judgment.
Much obliged, Your Honor. Your Honor, the council would like to highlight the fact that it is Article 32 is also a guaranteed fundamental right, but it is not meant for appellate. The council would like to draw the attention of the bench on para number 20 of the Moot proposition. Your Honor, the petitioner in the pertinent matter petitioned the Honorable High Court under Article 226 for quashing of FIR for interim release on bail, and he also challenged the constitutionality of Section 152 of Indian Penal Law. Your Honor, all of no relief has been granted by the Honorable High Court to the petition, and therefore he later on went on to petition the Honorable Supreme Court, and therefore the matter is before. If Your Honor is satisfied, the council seeks permission to
Please proceed.
much obliged. Your Honor, the council would like to highlight the case of Jindal Stainless Steel Limited versus State of Haryana. It was stated by Justice D.Y. Chandrachud as Honorable Chief Justice then was that the presumption of constitutionality or of a legislation being in the public interest does not confer protection or immunity against a specific challenge on the ground that it violates a constitutional limitation, such as that limiting legislative competence, the fundamental rights, or constitutional provisions. Further, Your Honor, the council would also like to highlight the case of Ramakrishna Dalmia versus S.R. Tandoori. Your Honor, it was highlighted that presumption of constitutionality cannot be carried to the extent of always holding that there is some undisclosure.
As a lawyer, we expect the counsel to first proceed. When you are addressing a code of law, first comes the text, then comes your contention. Then you have to support your contention with the assistance of case law. So case law is the third ingredient. It can't be the first ingredient.
Much obliged.
And there is a presumption that as students of law, we do know this law. So you proceed with the facts.
Much obliged, Your Honor.
That will be better because there is something and you are agreed by that particular thing. So kindly demonstrate that what you are challenging is unconstitutional.
Much obliged, Your Honor. Your Honor, the council would like to highlight that the very first contention is regarding the constitutionality of Section 152. Therefore, the council cannot place a lot of reliance on the facts of the issue. The facts will be placed with reliance on in the second issue where the content of the petition
Okay,
is.
no problem.
Much obliged, Your Honor. Since in this case highlighted that constitutionality, presumption of constitutionality cannot be carried on to an extent to always hold the legislation constitutional, even if it violates the fundamental rights. Your Honor, it is submitted that where petitioners are able to demonstrate through clear and cogent evidence that an impugn provision is made, the presumption can be overcome. Therefore, the protective cover of presumption of constitutionality cannot always be taken by the state to protect the enactment. Further, Your Honor, the second argument that is presented by the state is that it satisfies the test of reasonableness under Article 19 clause 2. And the state is relying on its power under Article 19 clause 2. When the council agrees that the state is entitled to impose reasonable restriction, the test of reasonableness must be satisfied. One of the principles for examining reasonableness is that there must be a direct and proximate nexus between the restrictions imposed and the aim that the state sought to achieve. Your Honor, in this particular section, the impugn provision, it criminalizes speech based on its content and viewpoint, not based on a demonstrated nexus to actual threats against sovereignty. Your Honor, therefore, it is submitted that it fails the test of proportionality. Lastly, Your Honor, the council would like to state that the impugn provision suffers from vagueness and is manifestly arbitrary. Your Honor, vagueness needs to be viewed from two perspectives. Firstly, that the enforcement discretion should be constrained, and secondly, that the people on which the law is being applied, the core prohibited conduct should be viewed. Your Honor, in the pertinent matter, the impugn provision, the council would like to draw the attention of the bench towards the clear language. It uses terms like secession, armed rebellion, subversive activities, encouraging feelings of separatist activities, or acts that endanger the sovereignty, unity, and integrity of India. Your Honor, all of these terms are neither properly defined by the legislature, nor have they provided a particular list as to which acts will fall into these categories. Your Honor, this ambiguity leaves the enforcement agencies with a lot of unfettered discretion as to when they want to apply this particular section to impose a blanket restriction on
What has the High Court said with regard to this particular provision?
Your Honor, the High Court has upheld the constitutional validity of section.
What is the reasoning that has been given by the court?
Your Honor, the moot proposition is silent. Much objective. Therefore, Your Honor, the council humbly submits that section 152, the terms which are used in it are vague to an extent that it leaves a lot of unfettered discretion on the enforcement agencies as to when they want to apply the section according to their own wills and values. Further, Your Honor, if we examine the issue from the second perspective, the court prohibited conduct of the section.
The court would like to pose a query to you.
Much objective.
Rather than holding that the statutory provision is unconstitutional, would it not be wise that in case some action is taken by the government by invoking that particular provision, then the court may go into that particular incident to judge as to whether the section has been rightly applied or wrongly applied. This is also a test.
Much obliged, Your Honor. The council absolutely acknowledges and respects the jurisdiction of the honorable bench in that matter. But Your Honor, the council would like to highlight that in that case also vagueness still needs to be removed from the exclusion provision because that would ultimately increase the arrears of the court. Further, Your Honor, it also needs to be taken into consideration that core prohibited conduct should be clear to the people of ordinary intelligence, to the class of people who on which the new law is being applied. Your Honor, a citizen cannot form the requisite intent to violate a particular provision if the core prohibited conduct is not clear. Further, Your Honor, the council is contending that the improved provision is manifestly arbitrary. The test of manifest arbitrariness was laid down in the case of Sharma versus Union of India. If Your Honor may kindly refer to flag B, page number 8 of the complaint, which states the test of manifest arbitrariness. Your Honor, the reason behind the legislation that has been impugned must be viewed from the public lens of public interest. Your Honor, the impugned provision does not work in public interest, but is a systematic silencing of dissent. Also, Your Honor, one of the settled principles leading to the application of test of whether the law has become arbitrary is that the object of the law no longer survives, where the operation of law does not have a certain existing purpose. Your Honor, the council would like to highlight that since the Constitution is a living document, all the provisions must be in consonance with the present march of time. Therefore, it is submitted that the honorable bench reconsider this provision and strike down accordingly. Your Honor, it is further submitted that currently the consideration of section 124A of the Personal IPC and section 152 of the New Sanhita is ongoing before the Honorable Supreme Court of India under the case of SG Mohammed Kere versus Union of India. Therefore, Your Honor, the council is humbly contending before the bench that the present provision does suffer from certain ambiguities. Therefore, the petition is going before the Honorable Court. Lastly, Your Honor, it is humbly contending before the bench that either the vagueness is either the impugned provision is struck down in entirety or an exhaustive list is provided by the Parliament as to which act is what in these particular categories to remove the view. If Your Honor is satisfied, the council seeks permission to proceed with the second contention that Mr. Paul's social media posts fall within the protected ambit of free speech under Article 19(1)(a) and does not amount to subversive activities. Your Honor, the council would first like to state the meaning of subversive activities as per Black's definition. It states that subversive activities is a pattern of acts designed to overthrow government by force or other illegal means. Your Honor, the very definition of the term leaves the entire case baseless because none of the acts of the petitioner amount to subversive activities. Your Honor, the very fact that the government became restless and slapped the petitioner with such high offences clearly states that the government is indeed trying to suppress dissent. Further, Your Honor, the element of purposely or doing that is given under section 152 is absent in the particular matter. If Your Honor may kindly refer to Black page number 29 of the compendium. If Your Honor are with me. Your Honor, it was said in the case of S. Kushbu versus Kanai Amar that it is not a task of criminal or to punish individuals merely for expressing unpopular views. The threshold for placing reasonable restrictions on freedom of speech and expression is indeed a very high one, and there should always be a presumption in favor of the accused in such Your Honor, it can be inferred from para number 14 and 15 of the Moot proposition that the petitioner in the pertinent matter relied on credible sources. He acted in good faith and on reasonable grounds. He showed his concerns regarding displacement, destruction of homes, and loss of life. He further highlighted governmental failures in healthcare and agriculture in the border districts. He showcased his concern regarding violation of international humanitarian laws during Operation Kumbh and civilian casualties. Your Honor, a journalist can be held liable for a report in the absence of proof that the published report was in the absence of proof that the published report was false or was published with deliberate disregard of truth. As Your Honor, in the pertinent matter, the petitioner relied on credible sources and he acted in good faith. He cannot be held liable for merely fulfilling his journalistic duty. Further, Your Honor, the counsel would highlight the explanation given in the section 152. It clearly states that comments expressing disapprobation of the measures or administrative or other actions of the government will not constitute an offence under this particular section. Therefore,
under these peculiar circumstances, where on one hand there is the issue of the liberty of an individual, vis-a-vis what will be the effect of what he is doing on the nation per se? Whose rights are the rights of an individual supreme to the ill effect of what he might be doing?
much obliged, Your Honor. Your Honor, the counsel would
Because that may also be a ground to test the legality of the statutory provision.
much obliged, Your Honor. Your Honor, the counsel would like to highlight that in cases of conflicting interest of individual rights and liberties and national security, a balance has to be struck between these two. Your Honor, the counsel would like to highlight the proportionality test that has been laid down in the case of modern dental college and research institute of the state of Madhya Pradesh, and further in the case of K.S. Kutteswamy versus Union of India. Your Honor, it was highlighted that the restrictions that are being imposed on fundamental rights should draw a rational nexus to the aim that the state wants to achieve. Your Honor, it is highlighted that in the pertinent matter, the state, the Republic of India, is in the guise of national security trying to impose a blanket restriction on freedom of speech and expression. Your Honor, after the post of the petition on 17th of February, if Your Honor may kindly refer to para number 16 of the Moot proposition, the government responded to the press release denying any wrongdoing, stating that Mr. Paul is trying to spread misinformation. Your Honor, it can be clearly seen that the state did not try to present any kind of evidences with regard to the civilian casualties or violation of international humanitarian law. They mainly denied any kind of wrongdoings, and they're basically trying to escape from any kind of responsibility with regard to rehabilitative measures that might be taken if there is any civilian casualty that is actually taken. Further, Your Honor, the council would like to draw the attention of the bench towards para number 18 of the Moot proposition. The intelligence dossier that was released by the Hindala Police Commission. None of the very last time of the para states that its veracity is disputed and no court has yet established any evidence. Therefore, Your Honor, since the state has prosecuted the petition in the pertinent matter, the burden of proof with regards to proving the criminal intent of the petitioner is entirely upon them. Your Honor, a leaked intelligence dossier whose veracity is disputed, it does not fulfill that burden of proving the criminal intent. Your Honor, further, it is highlighted that criticism of public leaders and comments on government action, however strongly worded, would be within reasonable limits and would be consistent with the fundamental rights of free speech and expression. Your Honor, the petitioner in the pertinent matter.
We'll give you 3 additional minutes for questions have been posed to you. Will you continue for
Much obliged. Your Honor, further, the council would like to highlight that since freedom of press is recognized to be a part of Article 19(1)(k), it is safe to say that it occupies a position of paramount importance, especially in a democratic country. Your Honor, it was highlighted in a canteen of judgment by the Honorable Supreme Court that the purpose of press is to advance public interest by publishing facts and opinions, without which a democratic electorate cannot make responsible. Your Honor, the petitioner in the pertinent matter made certain posts about Operation Kumbh, regarding which credible questions existed with regard to the civilian casualties and international humanitarian law. Therefore, the public has a compelling interest in knowing the Further, Your Honor, the state's contention that the High Court was correct in its order in its refusal to quash the FIR in regard to the petitioner. Your Honor, the counsel would like to highlight that as per that case, the High Court does have the power to quash the FIR if no prima facie offence is made. Your Honor, in the pertinent matter, with all due respect to the Honorable High Court, the High Court failed to exercise its constitutional scrutiny that has been granted to it under Article 226. Your Honor, in this pertinent matter, no prima facie offence was made against the petitioner because there is no incitement to violence or tendency to create public disorder as has been laid out in the case of Shreya Singh versus Union of India as well as Kedarnath Singh versus the state of Bihar. He mainly criticized government actions regarding which, again, the council would like to state critical questions existed with regard to civil cases. The High Court also ignored the chilling effect of the case. Your Honor, it is the court's duty to prevent the misuse of vague penal provisions. Your Honor, the High Court has not exercised any constitutional scrutiny which was needed in the Article 226. It basically relied on prima facie evidences and refused to grant any relief to the petitioner. Therefore, it is respectfully submitted before the honorable bench that the petitioner should not be held liable under section 152 of the Indian Act and his conduct was under the protected ambit of free speech under Article 19. Further, Your Honor, the council also submits that section 152 is vague and manifestly arbitrary and should be struck down. If Your Honor is satisfied, the council seeks permission to call upon the diamond of the council for further action. To the honorable bench, may it please support that this is the council appearing on behalf of the petitioner. The council shall be taking up third, fourth, and the fifth contention at hand. If Your Honor is satisfied, the council seeks permission to move the third. Much obliged. The council shall be dealing with the third contention, which is about the act of attempted self-immolation undertaken by the petitioner and whether or not it constitutes an offence under section 226 of the PN. The council shall be advancing the arguments within three legs. Firstly, the council shall discuss the legislative scope and intent of section 226. Secondly, the council shall argue upon the factual surroundings in the context of the petitioner's acts. And lastly, the council shall briefly discuss the political nature of an act of self-immolation. Your Honor, satisfied with the council begin with the argument. Much obliged. Your Honor, if the council may humbly present a historical background of this said petition. Under section 309 of the IPC, there was a blanket criminalization of all kinds of attempts to suicide. In response to that, the Mental Health Care Act, section 115, said that there shall be a presumption of mental distress in cases where a person attempts to commit suicide, and that no person shall be charged, tried, or convicted under section 309, and 309 was accordingly struck down. When the new criminal provision came, that is the BNS, in BNS, there was no general criminalization and that provision was entirely removed. Only section 226 was kept, and that section exclusively criminalizes only those attempts to suicide which are done with an intent to either compel a public servant or refrain that public servant from doing his or her duty. The Honor, it is humbly submitted that
when section 309 was declared as unconstitutional, what was the logic given by it?
Your Honor, it was not explicitly declared unconstitutional. It was laid down by the Mental Health Care Act, and it was said that in cases of attempts to suicide, there is
a very famous judgment of Honorable Supreme Court, P.
Indeed, the council is not well versed with that at the moment. However, the council may.
The logic given by the Honorable Supreme Court was that if suicide by itself is not punishable, then how can an attempt to commit an act which is not punishable can be made?
Indeed, Your Honor. Also, with due regard to sensitivity towards a person's mental health and the mental stress they are experiencing, the prosecution of that offence is deemed to be illogical and insensitive. In that regard, the presumption of mental distress was made in Mental Health Care Act. And in BNS, no such criminalization was there. But the council here is contending that section 226 addresses a specific kind of attempt to suicide, which is done with an intent to compel or restrain. Now, what the council is contending here primarily is that this intent becomes the central ingredient, essential ingredient of this provision, and that must be explicitly established by the prosecution in order to invoke this section. Now, the council will attempt to argue how this intent was not present in the petitioner's act. Notice the petitioner's act of self-immolation was undertaken during a background of political protest and societal unrest. The council is not denying at all that the petitioner did in fact announce his act beforehand. He did hold a placard stating "Truth burnt by bullets," and he did attempt to burn himself. There has been no dispute as to the attempt of this act of self-immolation. But the council merely put before the honorable bench what the petitioner did not do, as it is equally important in calculating his intent in the present offence. Your Honor, the petitioner did not issue any ultimatum to these authorities. The petitioner did not pose any threat. The petitioner did not make any deals or give any deadlines that if certain thing is not granted to me by the end of the day, I shall then self-immolate. The petitioner merely announced that I shall be committing this act, and that announcement was in isolation. Your Honor, on that note, the council also contends that unfortunately, had there been a loss of life of the petitioner, it was the sole responsibility and choice of the petitioner to have made that choice of sacrifice. Further, Your Honor, the council seeks to address the respondent's argument, which can also be that in matters of life and death, there is a moral choice, and then because the petitioner is claiming that there is a risk to his death after self-immolation, then the public servant is compelled to.
If on the issue of life and death, so I put it like this: that if the issue of life and death is an issue of moral choice, then why so much you will cry over euthanasia?
Much obliged, much
It
obliged.
is one of the latest judgments of the Honorable Supreme Court.
Indeed, Your Honor.
There also one is only saying that I want to die,
Indeed,
but it is not a moral choice.
Indeed, Your Honor. Indeed. So the line is between whether or not it feels moral to allow a person to die. What the council may be allowed to present an example before the honorable bench that, Your Honor, in 1990, during the anti-Mandal commission protests, a protester who was named Rajiv Goswami, he attempted to self-immolate, and he sustained 80 to 85% of these burn injuries, and unfortunately passed away in 2004. Following his sacrifice, over 60 incidents of self-immolation had occurred, and the deaths were all reported. The council may humbly present before the honorable bench that this protest was regarding the Mandal Commission's report to implement the 27% reservation policy in the OBC reservation in government jobs. Your Honor, in 1992, the Supreme Court upheld this report of the Mandal Commission, and till date, the reservation stands at 27%. What the council is here trying to contend that over 60 deaths were there in this particular matter. However, the judiciary did not find that reason enough to reverse this decision, and that life, the moral choice of life and death, was not deemed enough reason to be compelled to reverse this decision. Further, Your Honor, if the decision of the state is legally justified and survives the scrutiny of judiciary and reasonable.
You see, upholding of what the government did in Indira Sani's case,
Indeed,
it cannot be correlated to the act of 60 persons of self-immolating themselves.
much obliged.
For the reason that these are two isolated things.
Indeed.
You see, as what the Honorable Supreme Court was doing in Indira Sani's case, it was testing the validity, the constitutional validity of the Mandal Commission. Now, as far as right of agitation of a mass which was agreed by this kind of reservation, there is no issue that you cannot protest. In fact, what is Indira Sani? Indira Sani is also a protest, a legal protest to the act of the government, which was answered by the Honorable Supreme Court in favor of the government. It is also I'll put it like this, that is also a mode of protest.
Indeed.
When you come to the court and say that sir, this act of the government is unconstitutional, that is a mode of protest. You are protesting to it.
Indeed.
But who gives this person the right to self-immolate himself? Or rather make an attempt to self-immolate himself? Because probably, let us take a case that there is someone who is dejected with life and he makes an attempt to self-immolate. He is not doing it with any intent in his mind.
Indeed.
But here, you see, there is a saying that thought of a man cannot be tried, because even a devil knows not what a man. Now here is a person maybe who wants to come into island, just by trying to self-immolate, because intention is not to kill him. So then how do you justify this act and say that the statutory provision is there?
Much of that. If the council may humbly highlight that it is explicitly given in the factual matrix that the purpose of self-immolating was definitely to attract the public administration's attention. That is undisputed. However, the agenda of the entire text was to get accountability out of the government, primarily. Secondly, Your Honor, attempt is not disputed. Your Honor, the definition of an attempt in criminal law is that an act which is done with the intention to complete it, but it is only rendered partially fulfilled because of intervention. Your Honor, there was no intention of the petitioner to just use it as an emotional manipulation or a threat, since he had explicitly said that I shall be performing this act, and it was stopped by the police by intervention. It is humbly submitted that the intention was to commit this act, make that act. Further, Your Honor, the council has brought in the example of the Mandal Commission, not to draw any similarities between the subject matter of these cases and what was being protested, but merely the nature of the protest and the activities undertaken consequently. In anti-Mandal Commission protests, there was a decision of the government which the public opposed. In order to oppose that view of the government, they undertook various modes. Self-immolation was one of them. Now-
Incidentally, we all were students during this Mandal education and in university. I am not saying anything more than
Must be right, Your Honor.
we have seen it very, very close.
Must be right, Your Honor. Given that fact, I believe that the bench will show utmost.
And probably many of you were not even born.
Indeed, Your Honor. Given that fact, I believe that the bench will show utmost sensitivity and regard to this matter. In light of which the council argues that there was something which was being protested. In the mode of that protest was also undertaken through self-immolation. Now the state is arguing that because you are giving us an ultimatum of life and death, that if we don't intervene, you will die, I am compelled to perform a certain act. And that is what invokes Section 226. The council is simply arguing that when the matter of life and death did not compel the government to reverse the decision of Indira Sani because it was legally justified and sound and constitutional. Similar argument can also be applied here that since if the government's decision is sound and fair and constitutional, no threat of life and death can compel the government. Further, Your Honor, there is also where language of the provision says that if that act is also done with an intent to refrain a public servant from performing a duty. Your Honor, the respondents have failed to identify what exact duty the public servant could not perform. Your Honor, the duty of the public servant is to maintain public order. And she did perform her duty by intervening in the present matter. When self-immolation occurred, the DC did in fact intervene with police and the petitioner was rescued. And now in this scenario, the petitioner is maintaining his right to protest and the public officer is also maintaining her duty to maintain public order. In all of this backdrop, the respondent has failed to establish how the intent is explicit and it is done with an intent to compel or get any results out of the public service. If Your Honor is satisfied with the third contention, the council seeks permission to move on with the fourth contention. Much obliged, Your Honor. Contention 4 of the pertinent matter deals with invocation of three provisions of the IP Act, namely Section 66F, 69A, and 72 of the Information Technology Act. Your Honor, the council shall be dealing with each section in one leg of the act. Your Honor, to begin with, Section 66F deals with cyber terrorism. Cyber terrorism is the threat to sovereignty, security, and unity of the nation, which is caused through attacks on restricted computer systems, penetration without access, introduction of malicious code, exceeding authorized access, technological interference, unlawful intervention, denial of access, contamination of a computer system. Your Honor, the council may now only apply the petitioner's acts into the bare provision. Your Honor, the petitioner has collected a drone footage and NGO pictures from a local authority, the tribal video with his lawful consent given the video to the petitioner, and the petitioner has lawfully shared that videography and photos on his social media platform. The question petitioners are now posing to the state is that where have they justified the contamination of any computer source? Where is the intervention? Where is the interference? Where is the unauthorized access to any computer source? The drone footage was given to him with the consent of the person who shot that drone footage. The photos of that those burning villages was also given with the consent of the people who owned that data. Further, Your Honor, Section 66F has two parts, A and B. A was just dealt with by the council. The part B deals with incitement of violence and public disorder. Now, the council acknowledges that the provision provides that the public, that state need not prove that a disaster has already occurred. On the likelihood of causing damage, also the said provision can be invoked. However, Your Honor, if the council may humbly read the bare provision of 66F, Part B.
No, you see, again, the query that I posed to your learned friend also. When you are being challenged to the constitutional validity of a statutory provision. Now, what your contention is that in the facts of your case, this statutory provision has been wrongly read. That is subtly different from the statutory provision being per se unconstitutional. Because assuming there is a provision and it is being wrongly used, the courts can take it. And there is no need to hold that the statutory provision is ultra vires. And assuming, because what you are saying is that whatever you did does not fall, I put it like this, that there is no element of criminality in it. It is for the appropriate court to test. Why should the constitutional court go into it?
Much obliged. Indeed, Your Honor. The council may answer the honorable bench's question. There are 5 issues that we are gathered here to discuss. The first issue deals with whether or not Section 152 is constitutional or not. That contention is purely constitutional and not a question of fact. My learned co-counsel has brought in the arguments for unconstitutionality of that provision to address that contention.
Assuming it is unconstitutional.
Indeed.
For example, let us take a case.
Indeed.
What is unconstitutionality? Article 40.
Indeed.
Arbitrariness.
Indeed.
Basically,
Indeed.
those are the principles.
Indeed.
Old principles, classification, intelligibility.
Indeed.
Those are the basic. Let us assume tomorrow there is an amendment in the Himachal. Let us assume that there is a statute, Himachal Pradesh National Law University Act.
Indeed.
There is a statutory provision incorporated therein
Indeed.
that only those students will be given admission in LLB
Indeed.
who have MBBS degree.
Indeed.
It is unconstitutional. It is unconstitutional in the sense that what will be a boy with MBBS? I'm not saying that someone with MBBS degree cannot apply.
Indeed.
But if there is a statutory provision which bars everyone else and says that henceforth only those who have done MBBS will be eligible. Or let us put it like this, that tomorrow a statutory provision is incorporated that only those boys and girls will be allowed to get admission in this institute who can walk on their hands.
Indeed.
This is unconstitutional.
Indeed.
There is no need to quote an example.
Indeed.
This is arbitrary, this is unconstitutional. Because you see, when the test comes, what is the classification? Classification is that there is a set of boys and girls who can't walk on their hands, and there is a set of boys and girls who can walk on their hands. The issue is what this classification has got to do. What is the intelligible difference?
Indeed.
Nexus with the object. Nexus with the object is to educate people, to study law, to tomorrow argue as lawyers and sit as judges, etc. Now, here again, what the court is repeating is, will it be prudent for a court of law to say that a constitutional provision is unconstitutional? Sorry, a statute is unconstitutional. Solely on the ground that it is being abused by the state.
Indeed. As the honorable bench has given 2 examples, the council shall address them. Notice, if the council may humbly contend that the qualification example that the honorable bench had given about the MBBS degree, the honor, similar qualification of a different sort is applied. In order to get an admission into an LLB degree, you must have 12 passed out graduation. So now that is the qualification criteria that if it is presented, then that is not discriminatory discriminatory. It is merely a qualification required by the university for you to be admitted. However, so in that case, the council contends that that may be held constitutional, as it is also practiced nationally that a certain qualification needs to be there in order to get admission in any college. Further, the other example that the honors have provided about the ability of girls and boys to walk on their hands. Your honors, since that cannot be measured through intelligible differentia, that may be rendered as constitutional because that is not a recognized form of differentiating between two people, and it is humbly provided, submitted that certain discriminations are also allowed under Article 14 as long as they stand the test of intelligible differentia. So, while the test of qualification in order to land a job or get admission into a college may be constitutional and widely practiced, the difference between being able to walk on their hands or not may not be treated unconstitutional, may not be treated constitutional. Further, the council in the personal matter is contending firstly in the first question of law that whether or not this provision is constitutional. Moving on to the second, third, fourth, and fifth contention, those are questions of fact, where in the second issue, my co-counsel has tried to establish that in the said provision, argument was that it is held constitutional. Even if it was constitutional, the activities of the petitioners do not qualify into that provision, and the same may not be invoked against the petitioner. In the third contention, the council has tried to argue that the petitioner's acts do not constitute an offence under Section 226, which is also a fact-based argument. In the fourth contention, the council is presently trying to argue the fact that the petitioner's acts again do not invoke the said sections of the IT against him. The council is not challenging the constitutionality of these provisions, and the council believes that these provisions are in place for legitimate aim, that is national security, and they shall be protected constitutionally. The council shall, if the Your Honours are much obliged, Your Honours. Coming back to Section 66F, Your Honours, the ingredients, as the council has tried to specify, are attacks on restricted computer systems, unauthorized access, exceeding authorized access, contamination of computer resources, introduction of malicious codes, technological interference, etc. As the council also previously stated, the chain of collection of this data and then sharing it with the public was completely lawful, and the state has failed to establish any essential ingredient which is necessary to be there, to be invoked by Section 66F. Your Honours, the Part B of the provision, if the council may humbly read the bare provision, it is also provided at the end of the compendiums if Your Honours would like to refer to the bare language of the provision. Your Honours, Part B deals with whoever knowingly or intentionally penetrates or accesses the computer resource without authorization or exceeding authorized access, and by means of such conduct obtains access to such information, computer database that is restricted for reasons of security of state and foreign relations, and so on. The key word here, Your Honour, remains penetration or accesses without authentication or authorization. Your Honour, if the state is able to establish where this
But then there is one more question to be done for you.
Indeed.
You see, I take it that as far as many of these statutes, they are both procedural and substantive.
Indeed.
Procedural and manual.
Indeed.
Now, if everything has to be undergone by the High Court under Article 226 or the Supreme Court under Article 136 or 32, don't you think that the mechanism of criminal adjudication it will be rendered odious?
Much obliged. Indeed, Your Honour.
And otherwise also whether or not, you see, if they are invoking the provision and they have that allowed free to do. And if there is that element of criminality, the assumption is that you are innocent.
Indeed.
It is for them
To prove the guilt beyond reasonable doubt.
reasonable doubt that you are guilty.
Indeed, Your Honour.
So the criminal law will take care of it. Why the High Court? Because you see, under Article 226, disputed questions of fact are not to be adjudicated by.
Much obliged.
And the scope of the Supreme Court is much.
Indeed.
Article 226, constitutional rights, legal rights. 32, etc. only constitutional.
Indeed, Your Honour. The council acknowledges the words of the honourable bench, while the council may provide a perspective quite the contrary, that ideally, Supreme Court is not to examine questions of facts. SLP is exclusively a forum to address substantial questions of law. However, Your Honours, the trial is not many of these provisions don't even stand the prima facie threshold of invocation. The jurisdiction of those provisions are not invoked, namely the Section 72 of the IT Act. The Council shall argue upon that further. What the Council is trying to contend here is that grave provisions are mechanically invoked, that is a grave miscarriage of justice, and that is a valid ground for reaching out to the Supreme Court of.
So according to you, what is which is the monster amongst the two? The statutory provision or the act?
My apologies, no.
Which is the biggest monster? Bigger monster, I put it like this.
Amongst.
The statute and the invocation of the.
Much obliged, Your Honor. The Council has no arguments against the constitutionality of the provision and holds them to be extremely important to the.
You don't have to challenge the act.
Indeed, Your Honor, that is what the Council is trying to.
That cannot be written in Article 226. So there is nothing wrong with what the High Court has.
Much obliged, Your Honor. The Council is then the Council has.
We can dispose of a petition with an observation that the judgment passed by the High Court will have no bearing as far as.
Much obliged, Your Honor.
Please proceed. I will just.
Indeed. Your Honor, the Council's duty is to present.
I know I'm disturbing your line of thought.
Not.
But that is the very purpose I
Indeed not, Your Honor. If the Council may humbly submit that it's the Council's duty to present the perspective and the side of the coin to the Honorable Bench. It is up to their due wisdom to uphold pillars of justice as they are the ethics code of the country. Your Honor, if the Council may humbly contend that the Council is only challenging the invocation of these acts and not the constitutionality per se. Firstly, a few provisions. The Council shall skip to Section 72 to answer this question. Section 72 deals with breach of confidentiality. The language of the provision also provides at the end of the compendium states that any breach of confidentiality made by a person in pursuance of powers conferred to him under the Act. Your Honor, this provision was altogether made for people who derived their statutory authority from the IT Act itself. The petitioner is a journalist. He's only practicing his occupational capacity, and this provision was meant for a different class of people altogether, and the jurisdictional threshold of this provision has not been invoked. On the face of it appears, Your Honor, that there has been mechanical application, invocation of this act, and no legal application of mine. Your Honor, the greater question here is that it creates a fear of prosecution by intimidation, and that is also a grave miscarriage of justice, due to which the petitioner sought a writ in the state. By being aggrieved from that order, the Council is approached the Supreme Court. Your Honor, coming back to the cyber-terrorism argument, Your Honor, the state is empowered to invoke this section upon likelihood of incitement of violence and public disorder. Your Honor, the Council humbly pleads before this honorable bench that the state has also failed to establish the nexus between the petitioner's post and the incitement of violence. Also, to be noted, Your Honor, that in the factual matrix there has been no reporting of any violence. As the factual matrix goes, the protest was absolutely peaceful, which is a constitutionally protected right, and that cannot be requested of the public to shut down. The petitioner in his post, if Your Honor may kindly refer to the Moot proposition, paragraph number 16, 15 and 16, Your Honor. In paragraph 15, it is explicitly provided what the posts of the petitioner had said. He accuses the government of civilian casualties and quotes unmanned sources and claims the operation violated protocols under international humanitarian law. He also appeals for solidarity with tribal communities. Your Honor, the entire intention in response to this post, the government holds a press release, and instead of providing a realistic angle of what happened after the operation, they altogether deny any misconduct. Now, due to any substantial answer given by the government, that causes the public tension and the protests are broken up. Firstly, the protests were not violent, even if the state argues that the petition has caused public disorder. It is humbly submitted that it is the government's lack of accountability which has caused the public protest, and that entirely is the agenda of the protest to begin with. Your Honor, since there has been the state has failed to establish any rational nexus between the petitioner's post and the incitement to violence or any other essential ingredient of cyberterrorism, the same may not be invoked. On that note, the Council seeks to highlight the case law of Nalla versus State of Telangana, which Your Honours may find on flag number 22 of the compendium.
You may skip the case law and proceed further with your
Much of them.
solution.
Shall I state what the judgment is?
Please proceed. Come to your next sentence.
If the Council may briefly,
Until and unless they both have a link.
indeed, Your Honours. The Council may briefly give the arguments for Section 69A, which deals with the blocking orders issued against the post of the petition. Your Honours, Section 69A, where language reads that where necessary for sovereignty, integrity, and security of the state, access to any information generated, transmitted, received, hosted, or stored in any computer resource may be blocked by the central government or any authority having power to do so. Your Honours, as has already been highlighted by the Council, that there is no connection between the post and the protests which have broken out. So, by using the argument of the protest, is the state blocking this said post? Instead of examining the misconduct by the government which caused the public to protest to begin with, what the government is doing, they are doing a systemic silencing of political dissent and criticism. Instead of fixing what wrong has been committed, they are silencing the messenger who is raising awareness about these issues. If Your Honours may allow me to complete my much obliged, Your Honours. The Council shall state an important case law in this argument, which is State of UP versus Raj Ryan. Your Honours may find it on flag number 26 of the compendium. It states that the people of this country have right to know every public act, everything done in public way by their public functionaries. The responsibility of officials to justify their acts is the chief safeguard against oppression and corruption. Your Honours. The public has the right to know everything that is being done in the country, and if the Council may also state before the Honourable Bench that the public and the petitioner also in this matter is not claiming that the government should maintain transparency while an ongoing operation or during the planning or execution stage of the operation. But the government is mainly claiming, the petition is mainly claiming that there should be transparency after the operation has occurred. As was also seen after Operation Sindoor, Your Honours, the government had held elaborate press releases explaining the actions of the government which the public has a right to. If you are satisfied with this contention, the Council is permission to move on to the last contention at hand, which deals with the constitutionality of this blocking order which they had caused and whether or not it violates the fundamental right of the petitioner to freedom and speech. Your Honours, freedom of speech and expression. The Council humbly contends that the petitioner, as is already acknowledged, has a fundamental right in Article 91A. He has a right to disseminate information, he has a right to freedom of speech and expression, and in correspondence of this right, the public has a right to know and right to information. Journalism is an occupation where these rights are very central. If these rights are stripped off of the petitioner in turn loses his right to livelihood. So, in a cluster, all these rights are violated altogether. Your Honours, the Council humbly acknowledges that there are reasonable restrictions which can be imposed on these fundamental rights. However, the key word here remains that these restrictions should be reasonable. To check that reasonability and proportionality, K.S. Puttaswamy versus Union of India, which Your Honours may find on flag number 18 of the compendium, specifically laid down a four-legged proportionality test, from which the state's actions of restrictions must pass through. The legs of that test are as follows. Firstly, there is a legitimate aim. Secondly, there must be a rational nexus. Thirdly, there must be necessity. And lastly, that there must be a balance. The Council acknowledges that the state has one of the highest legitimate aim, which is the national security, and the Council does not seek to argue upon that and shall only present how these other three legs have not been complied with. In order to begin with, there has to be a rational nexus. The Council has already argued upon the fact, and will not take more of the bench's time in reiterating the same argument, that there has been no established rational nexus as to how the post of the petitioner broke out the protest, how the act of raising awareness caused the public to be in tension. So, that leg Council contends that stands uncomplied with. The leg of the proportionality test is that there must be test says that the means which is adopted by the government to curtail that right should be least restrictive, least intrusive. Your Honor, the council only contends that there were other things that the government could have done instead of outrightly blocking his social media posts. The government could have given clarifications upon the post. The government claims that the petitioner is spreading misinformation. In turn, the government can provide the right information which calms down the public. The government can release a counter post justifying the true nature of the events, and the government can maintain transparency to begin with so that these protests don't break out to cause the public order from the start. Your Honor, last leg of the test is balance. That there must be balance between the damage to right of an individual and the benefit achieved to the public. Your Honor, after blocking, if the state so claims that this post of the petitioner is allegedly causing all this public disorder and incitement to violence, then after blocking that post, all this incitement should stop. All this protest should stop because it was primarily the post's fault which is causing this. But no answer has been given. The protests are still ongoing, and that needs to be taken into account that there is no balance between what they wanted to do and whether or not it was accomplished. Further, Your Honor, the Council would like to highlight the case law of Madhya Broadcasting Limited versus Union of India, March Act flag number 29. It is a very recent case law of 2023, where the Supreme Court held explicitly that mere involvement of the issues concerning national security would not preclude the state's duty to act fairly. If Your Honors allow me to go further, the next doctrine that the Council would like to place before the Honorable Bench is the doctrine of imminent danger. The point, Your Honors, is largely the same, that if a rational nexus is established between the acts of the petitioner and the potential of it to cause violence, petitioner is a law-abiding citizen, Your Honors, and the petitioner shall submit to whatever punishment is granted to the petitioner. But the Council contends that no punishment shall be constitutional if it is not legally justified and scrutinized by this honorable judiciary. If Your Honor is satisfied with the contentions, the Council seeks permission to move with the prayer act. In light of the facts of the case, issues raised, arguments advanced, and authorities cited, the Council on behalf of the petitioners humbly pray before this honorable Supreme Court to adjudge and declare that Section 152 of the INS 2023 is unconstitutional as violative of Article 19(1)(a) of the Constitution of India and accordingly strike down said provision. Secondly, that the petitioner's social media posts constitute protective speech under Article 19(1)(a) and do not amount to subversive activity under Section 152 and quash proceedings thereafter. Thirdly, that Mr. Paul's attempted act of self-immolation does not constitute an offence under Section 226, and the Supreme Court quashed the FIR and proceedings initiated thereon. Fourthly, that the invocation of Section 66F, 69A, and 72 is unjustified and disproportionate and drop the charges thereunder. Lastly, that the blocking orders issued under Section 69A of the Information Technology Act against Mr. Rejoinder, the petitioner, are disproportionate, arbitrary, and violative of his fundamental rights and release him on bail at the earliest. Or passing either order, decree, or judgment that the bench deems fit in the best interest of justice, equity, and good conscience. And for this act of kindness, the Council on behalf of the petitioner, as in duty bound, shall select. Much obliged, Your Honor. It was an honor.
Greetings to the bench, Your Honor. The Council seeks permission to begin the round. Much obliged, Your Honor. May it please the court, this is the Council appearing on behalf of the respondent in the case of Mr. Rejoinder versus State of Kerala and the Council seeks permission to address the bench collectively as your lordships. Much obliged, Your Honor. Lordship, would you appreciate a brief perusal of facts? On the Council would be very delightful to submit on the respondent side very briefly. Much obliged, Your Lordship. Your Lordship, while dealing with this case, it is very pertinent to consider the background, the security prevailing security context, as well as the geographical location of the state of Himdala. We are looking Himdala, which is a border state, which has active insurgent claims, as well as there is a prevalent drone intrusions, which is given in paragraph number 11 of the Moot Compromise. Apart from this, there is also virtual intrusion through foreign funded social media campaigns that encourages separatist activities. Your Lordship, Mr. Revan Kaur, who is the journalist who is based in Himdala, after knowing all these prevailing security contexts, he deliberately shared misinformation regarding Operation Kumkum. He also deliberately shared the drone footages which is alleged to capture in and around restricted operative zone, upon which he was charged under section 152 of BNSA Lordships. Your Lordship, furthermore, Mr. Revan Kaur has also attempted to recourse to self-immolation during a protest, upon which he has been charged under section 226. Your Lordship, it is very pertinent to know that there is also an intelligence report in paragraph number 11 itself, where the, there is a presence of active insurgent and also the anti-national groups have coordinated to form covert operational base in rural Delhi, upon which the operational Kumkum was launched. Your Lordship, the presence of intelligence dossier also claims a link of contact with separatist groups with Rejoinder, based on which the charges were leveled against Mr. Rejoinder. Your Lordship, this Honorable High Court have rightly observed the presence of prima facie based on the social media post, the drone footage, and the alleged separatist contacts, contact of separatist groups. If Your Lordship satisfied with the facts, may I please proceed with my submission? Much obliged, Your Lordship. Your Lordship, at this point, the council would like to justify the council would like to justify the charges leveled against Mr. Revan Kaur. I will be presenting and be dealing with issue 1 and 2 regarding the constitutional validity of section 152 and the application in its present case. Where the Government Co-Council will be dealing the rest of the issues regarding the invocation of IT provisions, 226 application, as well as the validity of blocking order in the present case. If Your Lordship have no further question, may I please begin with my first issue? Much obliged, Your Lordship. Your Lordship, the Council humbly submits that Section 152 is constitutionally valid as it is not violative of Article 19(1)(a) and satisfies the test of necessity, arbitrariness, as well as it is proportional and least restrictive means. Your Lordship, at the outset, the Council would like to humbly submits that humbly acknowledges that freedom of speech and expression is very pertinent in a democratic state like Himdala, in a democratic state like Indica. But however, it is not absolute and reasonable restrictions can be placed in line with Article 19 Clause 2. With that being said, Your Lordship, Section 152 only targets acts that endangers sovereignty, integrity, and unity of the state, of the nation, which is an express ground recognized under Article 19 Clause 2. Therefore, there lies a presumption of constitutionality on the provision. If Your Lordships, have no further question till now, the council is
You see, if the provisions of section 152 or in the garb of what is contained in section 152, the state intends to silence those who are highlighting the high-handedness at the end of the state, then won't this section have the traps of being unconstitutional?
Your Lordship, much obliged. With respect to your question, the council humbly submits that section 152.
You see, you have not invoked the provisions of this particular act on the ground So you say so, but it has not been established in terms of the moot preposition. It is not your case that with the help of drone, etc., this gentleman is surveying some military areas of our country and sharing this information with the enemy. The preposition is because we have to take the preposition as it is. The preposition is very simple that there is an act at the end of the state which, according to the petitioner, is an act of high-handedness that has been recorded by him, which demonstrates that probably the power was used by the government not for the reason for which it wants the others to believe. And just to silence those who are highlighting the illegal acts of the government, you are invoking the provisions of this particular statute. You have invoked it once. Who can stop you from invoking it again and again and again and again? So there are types of unconstitutionality.
Whatever your lordship, with respect to your question, the council would like to humbly submit that section 152 protects lawful disapprobation in its explanation clause, where lawful disapprobation with the means of a lawful means requiring alteration in government can be explicitly protected under the section 152. Your lordship, but here the petitioner Rejoinder is not merely prosecuted under section 152 for criticism of government or just merely sharing the drone footage. It is the cumulative in the course of facts which the council will develop. The cumulative narrative which the
There is a very famous couplet. मेरा कातिल ही मेरा मुंसिफ है क्या मेरे हक में फैसला. You are the judge, you are the jury under 152. You are invoking this provision. You are the judge, you are the jury. Ultimately, God knows how much time will it take. Will it take ultimately for an appropriate court of law to decide whether the person was guilty or not? So does it not have the traps of being unconstitutional?
Your lordship, with respect to your question, the provision, the very wordings of the provision is very clear and very precise. And it has a reasonable standards to invoke. And also, your lordship, there are reasonable safeguards in BNSS to be more precise that while invoking section 152, the police officer has to submit mandatory report to the magistrate fortnightly and also conduct forensic report. And
there are means and there are ends. I am the government. The statute is in my hand. If I know what the end, if I already have decided as to what is the end, I will ensure that all the means take me towards that particular end. So it is, मैंने आपको कहा ना कि मेरा कातिल ही मेरा मुंसिफ क्या मेरे हक में फैसला. Police officer is mine. Whatever report has to be given by him, it will be a tutored report. So what are the safeguards against that?
Your lordship, with respect to the safeguards, the very provision, I would like to say 3 grounds on the safeguard provided by the section. Your lordship, the section 152 clearly have men's reas. Where, if your lordship could please refer page number 1 of our submitted compendium, where we have stated the explicit wording of the provision. Your lordship, if your lordship is with me, if your lordship is with me,
So you see, as far as criminal law is concerned, we all know actus non facit.
Yes.
We all know that.
yes.
But whether or not that act had the element of mens rea, ultimately a court of law will test. The question is that if there is a statutory provision which has the likelihood of being abused, adjudication, don't confuse the use of that particular section by the authorities with the process of adjudication. These are two totally different things. Adjudication is different. Invocation of that provision is different. Here, it is not adjudication, which is under test or under count. It is the invocation of that particular provision, the language of the provision, which according to the petitioner is unconstitutional because there is an element of it being abused.
Much obliged, your
No
lordship.
more questions now.
Much obliged, your lordship. Your lordship, thank you for your pertinent questions. The council would like to address on the same. Your lordship, firstly, the council submits that mere possibility of abuse cannot be a ground for striking down the validity of a specific statute, Your Lordship. It has been held by this honorable court in page number. This honorable court in the case of just a minute, Your Lordship. In the case of Collector of Customs versus Lathena, it has been cited in page number 179 of our submitted complaint, Your Lordship. Your Lordship, mere possibility of abuse cannot be a ground to strike down a statute as unreasonable or void. Moreover, Your Lordship, the Council only submits that this present provision has a reasonable standard and does not suffer from vagueness that can be lead to arbitrary application. Your Lordship, if you permit, I will briefly deconstruct the statute and say how it is not vague in its very term. If Your Lordship have no further question, may I please proceed with my arguments. Much obliged, Your Lordship. Your Lordship, with regard to vagueness, I would first like to draw a line of distinction between the Shreya single judgment, which dealt with the vagueness, the chilling effect and overbreadth, which is the very precise wideness that the petitioner is challenging here. Your Lordship, if you could, the council humbly summons that an act can be same in its manner, in its form, but the gravity, but the potential impact it has on its has on the public order is different. Your Lordship, Shreya Singhal dealt with ordinary online speech jurisprudence, which is section 66A. And also the term utilized in this, the employed in this section is very vague, like inconvenience, annoyance, etc. But Your Lordship, here, section 152 deals with a speech that threatens the national security. And if Your Lordship could please take page number 155.
Just go, let us read section 152.
Much obliged.
Whoever purposely or knowingly by words either spoken or written or by sign,
Yes, sir.
by doing like this, does it endanger the sovereignty of a country or the security of a country? So what is the thermometer with the state with which it will test that this particular sign or act committed by an individual with his body, etc. Because the word is this sign that it threatens the sovereignty.
Yes, sir.
And what is the proximate relationship between petitioner's post and the public disorder?
Much obliged, Your Lordship. With respect to the first question Lordship has put down, Lordship, the term endangers sovereignty is very broad, as the council acknowledges it. But the section 152 cannot be invoked just because an act can be included in endangering sovereignty. It should have a purposeful, knowingly disturbing, or have the tendency to incite public disorder.
No, you see, we are testing here the language of a state.
Yes, sir.
So the language is vague. It says fine. If I do like this, will it? You can say okay, he's endangering the country because probably a gun is always here. So he's trying to take out a gun and shoot someone. This may endanger the sovereignty, etc. Arrest him. Apply 150.
With respect,
Okay, no problem to see. Answer the query of our brother.
with respect
Don't
to
worry.
Cannot-
On behalf of the bench, I just make it very clear. We just take to question.
Your Lordship, the council is very glad to answer your question.
Don't get delayed. Don't get delayed. All of you are excellent. Answer the question.
Lordship, the council is very glad to answer your question and thank you for your pertinent question. Your Lordship, the very essence of the section is not to chill or suppress the criticism or dissent or any act of a citizen, but it's only targeting the acts that are openly threatening sovereignty and territorial integrity. Your Lordship, the very
See, I'm sorry, I'm again interrupting you.
yes,
Now read the other word, excites or attempts to excite.
yes, Your Lordship.
We all know Azadi, Azadi, I think everyone remembers. Azadi, Azadi. What if there is a child in a room and he's shouting against his mother, Azadi, Azadi?
What will be Your Lordship? Your Lordship, in
Let
the
us assume tomorrow the Honorable Vice Chancellor says that no student of this university will leave the premises after 4:30. And you start shouting Azadi, because you see, I'm putting this question to you because I'm using it in context with something which has recently happened. And when these kind of provisions were in, so what is the reaction of a young lawyer?
Your Lordship, with respect
Because
to
you are officer of the court.
much obliged, Your Lordship. Your Lordship, with respect to query, the council humbly submits that whenever a speech or whenever an expression being shouted or being placed in the public or only when it has the tendency to incite or disturb the public order that threatens the entire sovereignty, that threatens the entire territorial integrity. If your lordship, regarding the proximate nexus, which your lordship has clearly asked, I would like to deal that this section, very section, doesn't suffer from any vagueness, and the term subversive activities is judicial interpretation, where this term subversive activity has been clearly interpreted, clearly read along with the provision, entire provision. It has a clear nexus to the legitimate object, which is to suppress the acts that threatens the sovereignty, integrity, and territorial integrity of the nation. Your lordship, for this, the council would like to address the vagueness that the term subversive is not vague in the present provision, and this honorable court in a number of judgments has referred the term subversive activities in respect to the context of national security. If your lordship permits, may I please proceed with my arguments. Much obliged, your lordship. Your lordship, the council humbly submits that in case of P. Balakotia versus Union of India, which is in page number 199 of our submitted compendium, your lordship, where the honorable court has clearly held that the term subversive activities, though it is very wide, it cannot be said to be indefinite when it is read in context of national security. Your lordship, the council humbly submits that in the present case,
We'll give you 5 more minutes. You have about 8 to 10 minutes.
thank you, much obliged, thank you for your concern, your lordship. Your lordship, applying the very term subversive activity when read along with the other terms given in section 152, that is, whoever purposely or knowingly excites or attempts to excite by any means so and so, who excites or attempts to excite secession, armed rebellion, encourages separatist feeling or subversive activity.
I just make one point. Whenever you are in the midst of these moot court competitions, etc., please take into consideration one. It is not a debate. It is neither a declaration nor a debate. If you are referring to a statutory provision, feel free to refer to the statute. We are not testing you कि आपने रट्टा मारा हुआ है statute का. Feel free to refer to the statute. Because you are addressing us as a lawyer, and a lawyer has access to all this statute. And this time, this is also extension of it.
Thank you, lordship.
All interferences at our end.
Thank you, lordship. Your lordship, at this point, the council, in addition to the judgment referred, would also like to rely on 43rd Law Commission report, which is in page number 51 of our submitted compendium. Your lordship, if your lordship is with me, lordship 43rd Law Commission report dedicates a separate chapter to say what is subversive activities, and it has enumerated a specific list of acts which includes subversive activities. Your lordship, the Law Commission report identifies two core characteristics, which is one is intended to cause a split between the nation and the citizen, and the act operating at a preparatory stage, which is lordship is merely stressing. The acts operating at a preparatory stage prior to graver attacks on the state. Your lordship, the ultimate aim of the subversive activity is to destroy the bond between the citizen and the government established by law. Your lordship, if you are not permit me, I will clearly say, I will clearly demonstrate how in this particular case, the Mr. Van Kaul's post has clear list as being characterized as subversive activities under section 152. If you are not permit with me, much obliged, much. Your lordship, firstly, I would like to summon the submission. I would like to make the submission on 5 grounds. Your lordship, if you could please refer paragraph number uh, 14 and 15, where the very post, the wording of the post and the contents were being given. Your lordship, if your lordship is with me, the 5th line of paragraph number 14, that's the content of the post. Mr. Samir Rana records drone footage of smoke rising from village, which is shared with Mr. Kaur. Mr. Kaur posts a thread, alleging that Operation Kumkum was not merely a security operation but a political media ploy, orchestrated to divert attention from government failures in healthcare and agriculture in border districts. Your logic further in paragraph number 15, in his post, Mr. Kaur not only accuses the government of civilian casualties but also quotes unnamed sources who claim the operation violated protocols under international humanitarian law. He also appeals for the tribal solidarity, and the threat ends with symbolic photo of burnt hats and children fleeing images provided to him by a local NGO. Your Lordship, the council only submits that up to the point where the Mr. Van is criticizing the government is lawfully protected under the explanation clause. But however, the very drafting of the very language of the post is in a manner that creates a destabilizing narrative. If your lordship, I could I could attract the bench towards page number 96 of our compendium. Lordship, if I may attract the bench towards page number 96 of our compendium. Lord, if your lordship is with me, Mr.
You continue, please.
Much obliged.
Please do.
Your lordship, I have been relying on a norm 21A of journalistic norms. Whenever a journalist reports a news or any fact, he must investigate himself and verify it by himself. It shall not be a hearsay or indirect evidence provided by a third party. Your lordship, in the present factual matrix, the drone footage is not taken or not investigated, or the veracity of the drone footage is not checked up by the Mr. Ruvanto. It has been obtained from Mr. Samir Rana. Your lordship, it is very pertinent to note that during the Operation Kumkum, the very Operation Kumkum was launched in in reaction to counter insurgency.
Assuming I post something on the basis of something which is supplied to me in my life, how does that post become illegal?
What to make your lordship in respect to
Simply because I'm not the first person, and it has been told by videographer someone else who has shared it with me, and I've uploaded it. That does not liquidate the veracity of that particular thing. What is important is as to whether that particular thing is true or not.
much to make your lordship?
That will be the testing.
Much to make your lordship. Your lordship, the council here not admitting that just because of veracity, the drone footage is not true or it should not be used. Your lordship, the very contention of the petitioner, the very contention of the council is that the drone footage is alleged to capture in and around restricted operational zone. And this drone footage has the capacity or tendency to even show the alien enemies the modus operandi or the tactics which are being used in Operation Kumkum. As pointed, the very paragraph number 11 states that Operation Kumkum is to counter insurgents, and also the drone intrusions have been there. So when drone intrusions have been there, the very question of access of drone by a tribal leader and the capturing of drone during the Operation Kumkum is suspected, which is again a question of national security emerging. At this stage, the government is bound to protect national security emerging. Also, this very post is not only with regard to drone footage. Your Lordship, if I could refer paragraph number 15, the post ends with the image, symbolic image of children fleeing from burnt huts. Your Lordship, norm 27 of journalistic norms, which is in page number 99 of our compendium, which states that any image provided by a journalist or reported by a journalist should be true. And if they are editing, it should not be in a manner that it misleads or misrepresents.
Are these norms justiciable?
Your Lordship, these norms are given by Press Council of India.
Are they justiciable? Because you cannot test the legality or illegality of the act of someone on the basis of something which is not justiciable. You have invoked section 152. You have to justify your act on the basis of the statutory. You cannot rely upon this kind of material.
The council is not entirely relying on norms to prove the charges on section 152. The council is only trying. The council seeks permission to proceed. The council is only trying to show the intention of.
We are giving the 5 minutes.
Yes, Your Lordship. The council is only trying to show the intention of Mr. Rejoinder by sharing this post, coupled with along with the cumulative facts. It has a destabilizing narrative. Your Lordship, Your Lordship, this very post, this very image, which shows a symbolic burning hut, children fleeing from the burning hut, in the context of Rumal Valley, which has a historical tribal autonomy, and which has a insurgency, and the the very tribal has a tendency to house insurgents. Your Lordship, this image is emotionally charged and misleading and falsely portraying the state as it is setting a narrative that the state is acting against the citizens or civilian in a volatile region. But Your Lordship, it is very pertinent to note that the state is keep on trying to protect the citizens, is keep on trying to counter insurgents. But whereas the Mr. Vankov, after even knowing the prevailing security context, even being a journalist who ought to have known the norms of the journalistic conduct, he have deliberately acted in such a manner to give us such a destabilizing narrative, which in turn destabilizes the bond between the citizens and the nation in such a security context, Your Lordship. Your Lordship, also the post has appealed for tribal solidarity, which is, if Your Lordship has any question.
Many please.
Much obliged.
So this was just a sign.
Yes,
You reacted to my sign.
Your Lordship, the council thought that the bench had a question, that's why. Much obliged, Your Lordship. Your Lordship, moreover, he has also appealed for tribal solidarity in the very post. Okay. Much obliged.
You say on 15th February 2025, the Indian Armed Forces launched Operation Kumkum across borders striking remote mountainous areas, aimed to harbor insurgents. The way we understand it, cross borders would be beyond the boundaries of our nation. And if we see the next para, then there are local accounts began emerging from the article contradicting the official narrative. Eyewitnesses citing details that Managerial groups alleged that entire villages were raised, civilian population displaced, and dozens of non-combatants killed. If this is actually correct, which is not denied anywhere in the group proclamation, then how do you say that reporting about this would be an anti-national act?
Your Lordship, with me, with this much
Coupled with the question of brother, if this act of a journalist, you try to subvert by invoking section 152, then 152 becomes a, then there is valid in what the petitioner said. There is abuse of the statutory.
much obliged, Your Lordship. With respect to your question, Your Lordship, firstly, in paragraph number 16, the government, humbly serve the government submits that the information which Mr. Rejoinder has relied is entirely not based on any proof. And even the local accounts and eyewitnesses, it is purely a misinformation. Moreover, Your Lordship, here we have charged 152 on Mr. Rejoinder not for just merely reporting an incident. Your Lordship, that is why I am deconstructing the post, that the post has the element of tendency of creating public disorder by setting a narrative which is based on unverified facts. If Your Lordship is satisfied with the question.
One more thing, paragraph 21.
Yes,
What the Honorable High Court holds. Paragraph 21 regarding 226.
yes.
Concerning section 226, the High Court expresses concern that an attempt to self-harm intended to pressure a public servant might be covered under that section, but signals that more evidence is needed.
Much obliged, Your Lordship.
Any more evidence that has been collected?
Your Lordship, with respect to this question is dealt in issue 3, and this issue 3 will be dealt by my co-counsel, and your question will be addressed by my co-counsel. If that satisfies your question. Your Lordship, therefore, the very contention of the petitioner is that Mr. Rejoinder is residing. Lordship will conclude. Much obliged, Your Lordship. The very contention of the petitioner is that Mr. Rejoinder is relying on unverified sources in a manner that he sets up the narrative against the government, which in very term is subverting the government by undermining the lawful authority. So this clearly destroys the bond between the citizens and constitutionally protected government established by law. Moreover, Your Lordship, the Council humbly submits that Section 152 is constitutionally valid as it is very clear and precise in its term, and subversive activities have been clearly held valid by this constitutionally valid, and it poses an intelligible class of differentiation by this honorable throne. And therefore, we have a mere suspicion on Mr. Rejoinder that he poses a threat to national security. Considering this national security context, the government is bound to protect national security and bound to keep national security at a higher threshold. Therefore, Your Lordship, the Council humbly submits that the post of Mr. Rejoinder satisfies the prima facie case, and the Council humbly prays that it cannot be quashed, as the investigation ought to be happen to in turn verify the veracity of the council's contention, verify the veracity of post as well as the intelligent dossier which links Mr. Rejoinder with separatist groups. And if unchecked, the entire constitutional order will be in threat, Your Lordship, which the government is duty bound to protect. Much obliged, Your Lordship. If Your Lordship have any further questions, much obliged, Your Lordship. My co-counsel will be addressing.
Your Lordship's permission to approach the podium. Much obliged.
Clearly honorable your lordships. If you can read this note, I'll be the second counsel representing the respondents in this present case, your lordships. I'll be dealing with the next three issues, starting with section 226, an investigation under section 66 F and 72, and finally the validity of the blocking orders, your lordship. So starting with issue 3, I would like to start by answering the question put forth by honorable lordship. So in the observation made by the High Court as provided for in paragraph number 21, it has clearly stated that even presenting a public servant may come within the act of section 226. But as Lordship has rightly pointed out, it also calls for more evidences. But your Lordship, the petition before the High Court was one of quashing petition under section 528 of BNSS. So the threshold on the petitioners at that stage was in order to prove that there existed no prima facie case, your Lordship. So only by observing that there existed a prima facie case, the High Court has denied the quashing of the So denying of quashing that means that the case will be resumed before the trial court in order to adduce more evidences and in order to try the same evaluation. But for the reason that the same has came in a appeal before this honorable Supreme Court, I will be again evaluating the probative value of the evidences and will be proving how the essentials of section 226 are.
Let us read collectively section 222.
Indeed,
Let us read.
indeed.
Whoever attempts to commit suicide.
Yes.
So here there is an attempt to commit suicide.
Indeed.
With the intent to compel or restrain any public servant from discharging his official duty.
Indeed.
Which was that official duty which, according to you, the charged person either compelled the public officer to commit or restrained the public officer not?
Indeed.
Which was that? The public officer was either not committed. I put it like this: that which is that act which an officer was not doing, which he was legally obliged to perform, and feeling disgusted by it, he tried to self-immolate himself. Which is that act which he legally was bound, which legally he could have done, but in order to prevent him from doing that particular act, this particular act was performed by him. So which is that act? Because you see, you will have to appreciate one thing. Whatever has happened has happened. Operation Kumkum has already taken place. It is not as if there was a plan to undertake Operation Kumkum. In order to, I put it like this, that in order to ensure that the forces are not able to undertake this particular operation, he tried to self-immolate. So we have to read the language very, very carefully. Whether whoever attempts to commit suicide with the intent to compel or restrain any public servant from discharging his official duty will be punished. So you will have to demonstrate that there is a particular act which he either prevented from being done or he was compelling to be done, which otherwise was not within the domain of officer. Thereafter, assuming you can establish that, thereafter this issue can be adjudicated by the court of law as to whether there is merit in your contention or not. But in the absence of that particular act, will section 226 will go. So what is that act according to you from the Moot proposition?
Thank you for your question. In order to answer the same, I would like to point out two types of duty in this presentation. First is the intentional compulsion, second is the incidental compulsion. First on intentional compulsion, if I may analyze the facts of this case briefly, if I may refer to paragraph number 17 of the Moot proposition, your Honor, due regard must be given to the proximity of the place where the incident took place. The incident took place at the district commissioner office, and the act of self-immolation was directly done before Ms. Leena Arora. So who's Ms. Leena Arora? When we refer to paragraph number 6, we can find that she is the district commissioner and she is responsible for invoking all the security measures, and she is commended for the same as per your Honor. So when the accused Mr. Petitioner Mr. Rejoinder posted an express as provided in paragraph number 14 and 15, and the government promptly responded to the same, denying all the same in paragraph number 16. Appealed by this response in order to demand reversal of all the security activities the accused strategically appeared before the district commissionerate office, Your Lordship. It is also to be noted in paragraph number 16, it is clearly stated that protests were happening across India, but it was strategically chosen that Mr. Rejoinder will appear before the district commissionerate office not to demand the same. So this is the intentional compulsion that I was talking about, Your Lordship. And there also exists two nature of incidental compulsion. Your Lordship, it was not a peaceful protest. Mr. Accused set himself on fire. So by setting himself on fire, the police who are present there are organized in order to prevent the public nuisance which is happening there, Your Lordship. If I may invite the attention of Your Lordships to page number 12 of the submitted complaint here, that we have reproduced section 28 of the Police Act of 1862, Your Lordship. It clearly states that there is obligation of the police in order to prevent commission of a cognizable act as well as to ensure public order, Your Lordship. So this duty is compelled by the act of self-immolation. And the secondary nature is the harm against property and people present there, Your Lordship. The act was not done in isolation; it was done where many people were present, Your Lordship. So there exists high nature of threat that damage or injury may happen to the people present there or the property present there, Your Lordship. In order to substantiate this argument, I would like to rely on two reports reports headed by Fali Nariman and learned K.T. Thomas Committee, Your Lordship. If I may invite your attention to page number 47 of the submitted complaint here. Your Lordship, the Fali Nariman Committee on prevention of damage to public and private property was constituted based on the rate Andhra Pradesh judgment, Your Lordship. So that a pertinent observation was made. Whenever a protest turns violent, even a part of the protest turns violent, a person just by merely being part of the protest is presumed to be also constituting the violence, Your Lordship. And also in that page number 45, Your Lordship are with me, in the K.T. Thomas committee report, it is clearly stated that that's presumption of guilt in cases where there is damage to property and damage to injury to people in the public places, Your Lordship. So this is the second nature of duty that I am talking about. So I would also like to refer to an incident which happened in 2020, the Union Carbide Company, which processes many waste, trying to dispose the waste in the city of Pithampur town, Your Lordship. Continuing the same, two of the people self-immolated. This self-immolated is also an expression of protest, Your Lordship, but it was violent in nature because it injured the police who tried to prevent the same, and it injured the people who are present there, Your Lordship. So when we look at Article 19 of the Indian Constitution, that is right to protest, but it must be peaceful in nature, Your Lordship. This act of self-immolation is completely not peaceful and it is violent in nature, Your Lordship.
How do you say the ingredients of section 226 are satisfied?
Indeed, Your Lordship. To satisfy the question, that burden upon the respondent to say that on prima facie the ingredients are satisfied, Your Lordship. The two primary ingredients are attempt to commit suicide. Second one is this compulsion or restraint of duty, Your Lordship. With respect to attempt to commit suicide, the petitioners themselves considered that it was an attempt to commit suicide. But further, applying the legal standard identified in Malkiyat Singh case, Malkiyat Singh was a state of Punjab. It gave the principle on how to distinguish preparation from attempt, Your Lordship. It gave the test of withdrawal. In this present case, if not for the intervention of the police, he would have died, Your Lordship. So this is clearly an attempt to suicide. So this satisfies the first definition. Going to the second definition, as I have already enunciated upon the same, that here it is intentional in order to reverse the security actions and also incidental compulsion in order to take care of the safety of the people as well as protect the properties present there. So this clearly is the case falling within 226, but we are not asking for conviction of this forum. We are pleading to let the trial to do its duty, let that be a proper trial, and only at the end of the trial we know whether he is an acquitted or acquitted. We are just arguing against the quashing petition which is filed by the petitioner under section 528 of BNSS. If that satisfies your question, I will move to the constitutional aspect of this protest. Indeed, Indeed, Your Lordship, I will be dealing with the same now. Your Lordship, right to protest is guaranteed under Article 19. When 19.1a and 19.c are read together, there is also right to assemble peacefully without arms and as well as to express their opinion, Your Lordship. If I can refer to the landmark judgment in Ramlila Mina, it has also stated that the protest must be peaceful in nature. But I am establishing that in this present case, it is not peaceful in nature and it falls within the restriction provided in 19.2, which is the reasonable restriction, Your Lordship. I will be relying on the restriction of public order. In order to establish that there exists a public order concern in this present case, I'll be relying on the standard and or threshold which is observed in the Ram Manohar Lohia versus State of Bihar case. The very famous concentric circle says the larger circle represents law and order issue, the smaller circle represents public order, and the very smallest circle represents security of state laws. It is provided in page number 153 and 154 of the submitted complaints for the rules of your lordship. 153 and 154, your lordship.
Yes.
If your lordships are with me, they have clearly given an illustration also, your lordship, that not only the act, but the proximity of the act, that the act takes place, what is the intention of the act, also contributes to such a classification. In this case, the self-simulation does not happen in a closed space or does not happen in the house of the accused. It is to be pertinently noted that it happened in a public place. That too in the district commissionerate office before the district commissioner. So it is clearly a public order issue rather than a law and order issue.
There is one thing, taking a cue from what my brother has said. Let us again read this statutory scheme. Because you see, as far as Article 19, freedom, etc., there is a very famous quote that if freedom ends there, whereby knows limits. So I can do like this, but the moment I am in close vicinity to the those of my right of rights come to it. Now please see Article 226, sorry, section. Whoever attempts to commit suicide with the intent to compel or restrain any public servant from discharging his obligatory. Now, no one will be foolish enough to lock himself up in a room until and unless he is committing the act online. Until and unless that he locks himself inside a room and then commits suicide. So the legislature also recognizes that this attempt will be in public. Language is with the intent to compel or restrain any public. If this ingredient is missing, then unfortunately 226 is not complete. So what we are all asking you is that which is that particular act the accused person was either trying to compel you to do or restraining you from it. That is the motive. And it can't be an answer, Kisa, because there was public at large. We were there to protect this property. We were there to save the, rather protect the lives of the people standing out over there. Therefore, Article Section 226. I'm sorry, I'm using Article 226 because we are used to Article 226. So therefore, Section 226. Don't you think it's slightly powerful?
Your Lordship, I clearly understand the concern of your Lordship that there is clearly an overlap between Article 19, the right to protest, as well as how the protest is expressed and whether it will fall within the ambit of 226 or not. But here, again, the emphasis must be given to the peaceful nature of the protest. When we refer back to the paragraph which is talking about the protest, that is paragraph number 17 of the complaint.
Federal power is given. It's straight away. By virtue of this section.
Your Lordship,
see, the element of protest, it has got nothing to do with protest. Assuming I'm driving a car, someone stops me and says, give me your driving license or show me the validity certificate of the registration. I don't care. I say, if you insist, I'll shoot myself. That is 220. That is 220. This is not 220.
From the report of the Home Affairs, which was produced in the new Bharatiya Nyaya Samhita came into picture in 2023. This Bharatiya Nyaya Samhita decriminalized the attempt to suicide.
Okay. Unlike 152,
Indeed.
we are not testing the constitutional validity of 220. 152,
Indeed.
your friend argued, they were testing the constitutional validity.
Indeed.
Here, we don't have any quarrel with the language of this letter.
Indeed.
What we are trying to understand is that how have you invoked this particular provision vis-a-vis the conduct of the accused?
Indeed.
That is all.
Yeah.
You have to say.
Indeed. The council was trying to make a reference for observation, which is made by the committee members. That committee referred. So, Article Section 309, which is the attempt to suicide is decriminalized, but still Section 226 should be there because it is necessary to prevent public servants from being coerced. The same has happened in this present case. As I have already stated, there is clear proximal links, both geographically as personally. The very immolation happened in front of Ms. Reena. And if I may refer to a case where this 226 was applied in order to clarify the same. In the case of Sanya of the state of Tamil Nadu, the same section 226 was applied in Lordship. It was also a case of self-immolation. When the police arrived at the house of accused in order to pay the eviction notice, the accused denied for the same and explicitly poured kerosene on herself and clearly similar to the present case announced that she will set herself on fire. In that case, it was deemed sufficient on prima facie to continue the trial.
This is very close to the example I gave you.
Sorry,
What you have just now submitted, it is extremely close to the example I gave you. That I am driving my car. A police officer demands, show me your certificate. He has the legal right to demand it. But in order to ensure that he does not perform his duty, I say, यहाँ से भाग जाओ तो मैंने अपने आप को गोली मार.
The council also acknowledges that this is not the day-to-day application of this provision.
Assuming,
Indeed,
same incident took place 72 hours ago. 72 hours. And now I realize कि यार मेरे को तो गोली मार देनी चाहिए. I go to this candle point. I said that you see 72 hours ago, and that 72 hours ago, someone demanded a driving license from me, and therefore now I want to commit suicide. Will it attract 226?
Your Lordship, if I can answer to the same, that is case and mainstay must happen at the same transaction, Your Lordship, which is clearly happened in this present case. In this present case, when the compulsion was there, that was immediately he set himself on fire. So there was no delay in this present case, and it clearly expresses the intention in order to coerce and compel the public authorities, Your Lordship. So based on this, prima facie this offence is applicable, and the Washington petition is to be dismissed, Your Lordship. If Your Lordship is satisfied with this, I will address the mental health aspect of the same, Your Lordship. Your Lordship has rightly pointed out the judgments of P. Ratnam as well as Alma Shenberg and the Law Commission, two-time Law Commission report clearly decriminalized right to suicide and acknowledged right to die as per Your Lordship. But as the reference to mental health care was made by the petitioner, in 115 it is stated that the person who commits suicide is presumed to have severe mental illness, Your Lordship. We also make cognizance of this section also, Your Lordship. But by granting bail, the clearly laid out settled position of law will be taken into consideration. The landmark state of Rajasthan versus Balchan case, where Justice Krishna has clearly stated that there are multiple considerations which must be go into consideration. This includes the gravity of the offence as well as the heinousness of the crime. This here they are talking about national security. Where there are protests breaking out in the border country. There are possibility of anti-national groups. There are possibility of separatism. So this is indeed a grave offence. And it is also clearly stated that the accused suffered only minor injuries. So we are not denying him of any mental or physical health rights. We are as clearly provided in the DK Basu guidelines itself, Your Lordship. Once the person is arrested, every 48 hours he will be subjected to medical examination, Your Lordship. And also in the order of the High Court itself, it is explicitly stated that he should be provided with necessary medical assistance, Your Lordship. So there is no ground for demanding bail in this present case. If I may refer Your Lordship to page number 30 of our complaint, we have referred to an incident where granting of bail to a person who was associated with a separatist activity later resulted in further harm to the nation, Your Lordship. So in this present case, since it is also a case of separatism, it is also a case of anti-nationalism, reaching of the accused.
You see,
Indeed,
don't confuse 152 with 226. 152 is a different ballgame altogether. 226, what is the maximum fine that can be? What is the maximum punishment? 1 year. So, what about bail?
Your Lordship, I clearly acknowledge your consideration. Here, the FIR is made out for both 152 as well as 226.
152 is a but even as per you 226 is not a break.
Your Lordship,
आप कहते हैं community service कर दो 1 साल की सजा दो.
Your Lordship,
So you yourself are not too serious about 226.
the same, Your Lordship. Even the 226 is not.
226 is only so that 152 does not feel isolated. And 152 has some company.
He not. Beg to differ from Your Lordship. To clarify the same, both the offences 142 and 226 are committed with the same individual. So it is a question of bail for Mr. Rejoinder. Releasing him will also jeopardize the ongoing investigation for 142 as well. And it is to be noted that this present case involves drone videos as well as electronic evidences. This court has time and again has acknowledged that in cases of electronic evidences, there is high possibility to tampering the evidence after the commission of the offence. So releasing of Mr. Rejoinder will also jeopardize 142. Though this present issues is only with regard to 226. If this satisfies all the conditions of your lordship, we will move to issue 4 with regard to idea. Your lordship, I would like to set out the facts and the burden of proof clearly before moving into this issue. Based on paragraph number 21, this clearly stated that the FIR is only for 152 and 226 your lordship. But in issue 4, the contentious question is whether investigation for 66F and 67 can take place. Your lordship, court is entitled to investigate all the related offences, your lordship. If I refer to 175 of BNSS as well as 80 of IDR, your lordship, they are entitled to investigate for the same. But here in this present case, the petitions are contended even the investigation should not take place. They have referred to the jurisprudence which is set out in R.B. Kapoor, Bhajan Singh, Zandu Pharmaceutical, and latest in the Niharika infrastructure case in 2020. If I may refer to the Niharika infrastructure case, which is just a moment, Niharika infrastructure case, which is provided in page number 249 of the submitted complaint, it clearly states that when all the information disclosed in the FIR does not make out any cognizable or any kind of offense, only then the FIR can be quashed. So this burden is upon the petitioner to prove the same, and only upon a draft of fact cases, only if the continuation of the trial will lead to miscarriage of justice or abuse of process of law, the abuse of process of law, only in such cases the quash can be granted. So the petitioners have failed to establish that no prima facie case exists, and I will establish that clearly for cyberterrorism under 66 years, breach of confidentiality under 72, that this is the prima facie case. If I may start with cyberterrorism, if your lordships are okay. Indeed, your lordships. Your lordship, page number 18 of the submitted complaint reproduces the exact provision, your lordship. The section 66 here. Since the same has been already elaborated by the petitioners, I would like to briefly say what are the essentials of your lordship. Your lordship, it requires that access to computer resource must be there. I'm dealing with the second provision in 66 here, your lordship. First one deals with the offences of higher gravity, which involves which results in injury or death or affecting the supply, essential supply. We are not contending under that provision. Under the second provision, there are 3 essentials, which include first, access to computer resource. The access must be for a restricted area. Ultimately, it must lead to a danger to the security of the nation, sovereignty, integrity, and all those grounds which are listed under 92 as well. This is the brief, or in essence, this is cyberterrorism in the provision. Now, coming to the facts of the case, I'll establish how computer resource is involved, how there is restricted information, and how it is adversarial to the national interest. Starting with the computer resource. Your lordship, if I may refer to the definition of computer resource, computer system, which is provided in section 2(1)L of the IDR, it clearly states it includes all input and output system, except non-programmable calculators. Your lordship. So this clearly shows what is the intent of the legislation. So all advanced electronics and inventions is to be considered as computer system. Your lordship. And there has been multiple cases, even when CCTV footage is considered to be a computer system. Your lordship. If I may refer to the case of K. Ramajayam versus inspector, the same has been done. Your lordship. Even CCTV footage is considered to be a computer system. In this present case, it is not only a footage. Your lordship. It is the footage recorded by a drone, which is much more advanced in nature. Your lordship. So clearly there is prima facie involvement of a computer resource. Your lordship. If this is satisfied, I may move to how there is restricted information in this present case. Your lordship, so in order to establish how this information, the video of the Ripman Valley is confidential in nature, we must understand the factual background of this case. Your lordship. It is clearly stated in paragraph number 11 that there exists multiple anti-national propaganda and separatist activities in this group, and there are also many instances of insurgencies as well as drone incursions. Indeed, your lordship.
Let us assume that videography or photography is prohibited in a particular case.
Indeed, your lordship.
Despite that, someone either clicks certain photographs of it, or he videographs the area with the help of a drone, then the act will be an offense, because the person is indulging in something which is prohibited.
Indeed, your lordship.
Here, subject to correction, the Moot proposition does not suggest that videography was prohibited in that particular. So how will it be an offense?
Indeed, invade your attention to the 2 of the clarifications provided along the Moot problem.
Yes.
Your lordship with me. It clearly states that the operation Your Lordship are with me? Yes, Your Lordship. It clearly states that the operation Pum Pum clearly notified what is restrictive operational zone, Your Lordship. So this clearly states that videography and photography is prohibited in that region. If this satisfies your query, I'll delve more into the facts and state how this is confidential in nature. Your Lordship.
See, there are
Indeed, Your Lordship.
whether what was videographed was the action of the armed forces or was it the aftermath of the armed forces?
If,
It appears that what was videographed was only the aftermath thereof.
we also
It is not as if per se the operation was videographed.
Indeed, Your
And if the operation was allowed to be videographed, then what kind of force this country is having?
we indeed consider your question. It is indeed the aftermath that is being videographed. But even the aftermath is of high relevance to national security. I will elucidate how it works. Because in the aftermath, that will be used bullets, that will be used bombarded particles. So it will clearly reveal what is the strategy or tactics which is being used by Indian Army. And it will also reveal what is the armory, what is the inventory that the army has developed. These are very essential strategic information which will be of grave threat if it is given to the any alien enemy here. So Mr. Rejoinder made this confidential information global by publishing it in a social media platform.
The rights which are guaranteed under the constitution of so-called country Indica, fundamental rights. Are they for the citizens of that country or for the army of that country?
It is indeed for the citizens, but it is to be
So whose rights are supreme? If in the garb of army action, the rights of citizens, and you see, if you go through Article 14 and 21, they don't refer to citizens. Article 14 and Article 21, those fundamental rights are available 20%. Unlike other fundamental rights, they are citizen-centric. These two articles are not.
Yes, sir.
So,
Your Lordship, it is true that the expression of opinion of Mr. Rejoinder is to be respected and it is placed on a higher pedestal. Your Lordship. It is a constitutionally guaranteed fundamental right. But Your Lordship, it is also subjected to some restrictions under 19 and under 19 law. So that is the primary contention of the respondent. In the interest of national security, in the interest of sovereignty, unity, and integrity of India, if the information, if the Your Lordship, I seek an extension of much of the if the information with regard to the aftermath videos is being published, it will be clearly adversarial to the interest of India and all national. It will undermine the security of the same. It will provide confidential information to terrorists, groups as well as anti-national activists who will use it to their advantage. So it is clearly a national security concern, and in that circumstances, the fundamental right is to be subsidized. So that is exactly what happened in this case as well. If that satisfies your question, also the videography of the topography of the village is also confidential information.
that's why the query put by the court to you was, where is the prohibition that this particular area is prohibited as far as videography or photography is concerned?
Indeed.
And with regard to your contention that in a warlike situation, probably videography, etc., have you seen this border 2 which has been released very, very recently?
So,
If after the movie is over, you will see an actual clip of Indian army, our soldiers dancing on the tanks which were captured of the Pakistan. So this is something which is otherwise permissible. Anyway, proceed.
Your Lordship, my argument that the topography is also confidential is based on the fact of the statute which is Official Secrets Act. Your Lordship. In the definition of the Official Secrets Act itself, in section 2, it clearly defines what is sketches. Your Lordship. Any representation of anything is a sketch. Your Lordship. And in section 3, it clearly states if such information is conveyed to a foreign enemy, it amounts to spying. So in this present case, that is a contention. It clearly violates confidentiality. It clearly undermines the security and the integrity of the country. So on the and also the prima facie necessity or prima facie threshold for cyber terrorism is very low. To substantiate the same, I would like to learn two cases how they elucidate how they have identified the prima facie threshold. Firstly, the Brahmos case. In the case of Nishant Agarwal versus the anti-terrorist squad Lucknow. This is a case where he was an ex-scientist at the Brahmos missile facility, which is present in Hyderabad. There was an allegation that confidential information is found in his personal device. Only merely based on this allegation, a prima facie case was admitted. So the threshold is very low. If I may also refer to another case of NSA, which is the NIA, which is the National Investigation Agency, 66F is one of the scheduled offense of NIA also. It is also pertinent to note. In the case of state of Karnataka versus MM Biswas, it is the case where a person is prosecuted under 66F for mere sharing of tweets and retweets of a terrorist organization. There was no prima facie evidence as to there was an unauthorized access or anything. If there is even a minute concern, the threshold is kept very low because this is a very important matter. This is the question of national security that we are talking. So, for 66F, there exists prima facie case here. This brings me to my next one, that is section 72, which is breach of confidentiality. In the same page here, in page number 18, the provision is reproduced. If I may say this provision in essence, any person who contradicts any power under this act, if he secures access without consent, it is an offense. Here, indeed, Mr. Rejoinder, who is a journalist, was also empowered under the act. Not to make this observation, I am relying on the IT Intermediate Guidelines and Digital Ethics Code Rules 2021, which is provided in page number 20 of the compendium. It clearly defines who are news or current affairs contenders or who the publisher of news and current affairs contenders here. If the claims of the accused are taken as such, if he is really an investigative journalist, he comes within the ambit of the same year. So he is also bound by all the guidelines set in the rules, also the code of ethics provided in that rules here. So he is indeed empowered under the IP Act. Secondly, he secures access to your option. To understand what the scope of section 72 is, I would like to rely on the observation of Bombay High Court, where they compare section 72 with 403 and 406 of IPC. Those cases clearly show criminal breach of risk as well as criminal misappropriation. In page number 268, I have clearly provided the same that mere securing of access to an electronic record is sufficient for the same record. Here, the section securement was made, so it is indeed prosecutionable prima facie under section 72. I may also make reference to Drone Rules 2021. So under Drone Rules 2021, they have classified the overall aspects into three categories: yellow, green, and red. In red category, if you want to fly a drone, then you have to get prior approval of the central government. It is clearly provided in rule number 22 of the drone rules. Drone rules which is provided to just now. So in order to fly in a red zone, and the restricted operational zone is the Indian red zone. So they should have obtained seek an extension of this domain. So they must have got the permission of the central government before playing the same. They cannot be ignorant of the same as well, because if we refer to rule number 22 and 23 and 24, it clearly states that this is a real-time market. That's a dedicated platform called Digital Sky, where all this information with regard to the classification of zones will be updated on real time, and that's obligation on the person who is operating the drone to verify the same before taking off of the drone. So here he has blatantly failed to carry out this regulation. He has failed to verify whether this was a green zone or not.
But then you have to book him for violating these rules.
Indeed,
You see, these are rules.
indeed,
I take it that these are statutory rules. They must have been framed by invoking the provision of some particular act. So these rules have been framed under what act?
Your Lordship, the footage was done by Mr. Samir. He'll be.
These are what we have shown to the court are.
Yes, indeed, Your Lordship.
Now these rules, they are statutory rules. They owe their origin to a particular act.
Yes.
So violation, if any, is of that particular act, and the rules framed there.
Indeed,
For the breach of that particular act,
indeed,
which obviously is a substantive act, how can we invoke the provisions of this?
indeed.
Until these rules have been framed under that. I am also not aware, so I am posing a question.
I acknowledge that these rules are made under the idea. It is made under the act. But in this present case, I am not relying on these rules in order to establish certain portfolio. And the second rule that there was no consent because the central government approval or authorization was not obtained here. So the case involves both Mr. Samir Rana and Mr. Rejoinder cumulative. When taken together, they will be liable under section 72. But when Mr. Samir Rana taken individually, as your Lordship has rightly pointed out, he will be liable under the rules as well. Section rule 51 clearly points out penalty up to 1 lakh. So Mr. Samir Rana will be liable for that penalty. But when it comes to section 72, this is a question of Mr. Rejoinder.
In this case, the journalist, the petitioner, he has received the footage Okay, of the tribal leader voluntarily
Indeed, Your
and not by accessing the statutory.
Your Lordship, when you refer to section 72 clearly, it states that without consent, whenever there is an exceeding the authorization, Your Lordship. So, again, making reference to paragraph number 2 of the clarification, in a restricted operation zone, they should have obtained permission prior.
But he did not access the statutory authority.
Pardon, Your Lordship.
The petitioner, he did not access,
Indeed.
obtain access through statutory authority.
Your Lordship, I would beg to differ from the same, Your Lordship, because under the IT intermediary guidelines and digital media ethics rules of 2021, it is clearly stated in section 8 that this rule applies to publishers of news and social media content. Your Lordship.
Section 72.
Indeed, Your Lordship, but section 72 poses three essential, Your Lordship. First, he must be empowered under media. Second, there must be an restricted information which is bought. Finally, there should have been no consent, Your Lordship. With regard to the first element alone, to be empowered as a media and placing claims on the 2021 rules, Your Lordship. The definition 2 clause 1 clause C clearly defines who a publisher of news and social media content is, Your Lordship. This is not only the news houses and print media, Your Lordship. It also includes a person who is publishing the same under any name. If we refer to the definition itself, it even includes an investigative journalist as in the present case, Your Lordship. So indeed, Mr. Rejoinder is prosecutionable on prima facie under section 70, Your Lordship. If that satisfies your question, I would like to move to 69A. Your Lordship, due to the paucity of time, I would like to club 69A's procedural aspect along with the substantial question in issue 5, Your Lordship. Firstly, I will be dealing with the procedural aspect. Your Lordship, in order to issue a valid blocking order under section 69A, which is also reproduced in page number.
If you go to section 72, probably section 72 might not be affected at all. Let us read section 72 together. My brother has rightly pointed, please, they were otherwise provided in this act or any other law for the terminating code. If any person who, in pursuance of any of the powers conferred under this act, rules or regulations made thereunder, has secured access. Let's pause here. So, first of all, section 72 can be applied only on such a person who at the first instance has the authority or no, not only that, has secured access to any, who in pursuance of any power. So it is not intrusion which is punishable. It is abuse of the power conferred upon a person, which is punishable under 72. So that is the subtle difference. So assuming I have the power, but I abuse my power, then 72 is attractive. A stranger cannot be booked under 72 as I read it, subject to what you say.
The prosecution of under section 72 was for Mr. Rejoinder, who is a journalist in this presentation.
Journalist, yes. But
Indeed.
please read it again. Let's
Indeed. Same as otherwise provided in this act or any other law for the time being in force, if any person who, in pursuance of any powers conferred under this act, rules or regulations made therein. So here I am making high reference to the rules made under the same. In 2021 rules, he is clearly a publisher of news and current affairs content. So he comes within the ambit of section 70. This brings me to my final under section 69. Your Lordship, the ITAT also issued rules, that is 2009 blocking rules, in order to ensure procedural compliance. If I may refer to the rules, which is provided in page number 23 and 24 of the submitted complaint, the rules necessitate that whenever that it clearly establishes structure, well, break down the structure for your convenience, there exists three kinds of authority. Firstly, a nodal officer, to whom the complaint will be filed. Secondly, the authorized officer, who will carry identification of originator, who originated the message, who is the intermediary. Finally, the competent authority, which is the Ministry of ICT. So here, if I may make reference to paragraph number 13 of the clarifications, it is clearly stated that only the competent authority should the blocking order. So for the competent authority to issue, it has to go through these two stages here. Firstly, the nodal officer receives the complaint. Secondly, the authorized officer satisfies rule 8 and rule 9. Only upon satisfaction, the competent authority itself can provide the same. So this clarifies the procedural ambiguity in this case, and that is clearly procedural compliance here. If your options are satisfied, I may go into the substantive question of law how 19(1)(a) is not violated in this present case. Your Lordship, I would like to somewhat extract from another Boston case in order to lay for the same. Your Lordship, placing heavy reliance on another Boston case because it is heavily similar to the present case, Your Lordship. That the state of Jammu and Kashmir is also a border state. It also faced many insurgent activities as well as terrorist activities, and even in that case, there was a suspension of internet, which is also suspending the means of Article 1918. So the facts are very much identical, and it has high value in this present case also. This is provided by the same code as well. In this case, they have learned senior counsel Mr. Kapil Sibal was making this argument. He clearly said that the blanket ban is the main concern of the present case, because all the communication services, all the internet was banned toward the state of Jammu and Kashmir in that case. But in this present case, applying the test of proportionality, only the person who is of concern here, Mr. Revan Kaur, only his social media posts are being removed. Even in that case, when Tushar Mehta was arguing, he clearly stated that in that incident, there was no capability to identify who is causing harm and who is not causing harm. In this present case, that clearly we can identify that the social media posts led to all the issues, and only the social media posts are related to Mr. Kaur or Manvir. The same is given in paragraph number 13 of the clarification. If this clarifies the proportionality standard, and this also clarifies the proportionality test. If I may refer to page number 52 of the submitted extract of Anuradha Basin judgment. It states the proportionality rules from two important judgments. Firstly, the model dental college. Secondly, the Puttaswamy judgment. In Puttaswamy judgment, also they place higher range to resorting to a least restrictive means. Compared to Anuradha Basin, this is the very least restrictive measure that can be placed because only an individual is identified, only the social media post is identified. Even in Anuradha Basin case, they suggested banning of all social media platforms. We are not referring to that extent also. Only the individual is identified, only he is being logged. And also, in order to identify what constitutes an emergency situation, even in Anuradha Basin, they have made a clear observation in paragraph number 78 and 79 that with respect to all the grounds stated in 1902, only the public authorities are the right bodies in order to identify whether there is an emergency situation or not in your experience. So, in this present case, as I have already emphasized, considering the government white paper report, which is provided in paragraph 3 of the proposition, from 2022, there has been 17 such reported incidents where social media online campaigns were funded by foreign agencies. So, considering this in context, and also the intelligence report, which also incriminates Mr. Revan Kaur, it is very much necessary, and the public authorities are rightly blocking all the social media posts of Mr. Revan Kaur. This brings me to the final submission, last final submission. This is clearly a case of national security concern. Similarly, when social media platforms were banned in 2019, the Ministry of Director General of Military Intelligence issued a guideline. It clearly stated that the social media platforms may not be used by all the armed persons. This very guidelines was challenged before the Delhi High Court in the case of Lieutenant Colonel P.K. Chaudhary versus Union of India. That court has made several observations, which is provided in page number 272 to 73 of the submitted company reports. It clearly states that national security is a policy matter, not a matter of law. Secondly, it is the expertise of the executives who can make a correct recent decision, and the court should defer to the same level. So, placing reliance upon this thing, only the executives know what the ground level situations are, and also they have carried out the insurgent activities as well as anti-national activities has been prevailing there for over a period of time. So, they are very much equipped on the very modern threats and hybrid means of such terrorism as well. And it is also to be noted in paragraph number 33 of Anuradha Basin judgment, this Honorable High Court has recognized that internet is also being used as a medium of terrorism because the false propaganda, also spreading of misinformation, clearly agitates the people and also questions the entire validity and national security approach. So it is indeed a national security concern, and in this present case, the blocking order is well within the ambit of 19.2 restrictions, and they are reasonable in nature. With this, I would like to conclude with just 2 to 3 factual rebuttals to the arguments made by the petitioners. Firstly, they contended that the veracity of the intelligence dossier, which is provided in paragraph number 18, is contended. In order to ensure the veracity, the investigation must be permitted. In this present case, they themselves are asking for questioning of investigation, and they themselves are questioning the veracity. This is being a self-contradictory nature of themselves. Secondly, with respect to the NGO pictures, they have stated that they obtained the picture from an NGO and posted the same as provided in paragraph number 15 of the proposition. Your Lordship, they are not original pictures. They are symbolic pictures, Your Lordship. So the pictures, they may even be exaggerated. They may not reflect the actual situation. So when you are reporting a journalist, when you are a journalist and reporting the same, you should make sure that the sources are reliable and the information or photos attested to the same convey the actual picture. Your Lordship. The same is given in norm number 27 of the journalistic content as well. But in this present case, they have morphed the image. They have used a different image rather than the original image. So that contention is also being rebutted. Finally, with respect to 152 year, how the exists procedural safeguard. 142 is also an offense against state year. But there exists a different classification for 152 alone. Because when we refer to BSA section 115, it states that only for certain kinds of offences there is reverse burden of proof. When you make an offence against the state, you are presumed to be guilty rather than innocent. But 152 does not come within the ambit of section 115 of BSA. So they clearly enjoy the benefit of presumption of innocence. So we request the court in order to direct the resumption of the trial court. So when the trial is taking place, they are presumed to be innocent, but only on the completion of the trial, we are asking for acquittal or conviction for the offense.
What was the plea raised by a former Supreme Court judge in the case of Nirav Modi before UK courts?
Your one for sending him back to India and prosecuting.
Yes, it is there in probably you must be busy with your mood courts. You might not have read the newspapers.
Sorry, Your Lordship. I'll read the same answer, Your Lordship.
Somehow it is correlated to what you are and in your
Indeed, Your Lordship. So that is clearly presumption of innocence, Your Lordship. So the primary contention of our respondents is that the High Court has slightly adjudicated the matter. They have clearly dismissed the quashing petition, and they have clearly redirected the case back to the trial court. But here, appealing the same is wasting the precious time of this court, because there are no new facts which are being introduced. And on prima facie, as I have already elaborated, there exists offense. So it must be permitted for the investigation to continue. If there are no further queries from your side, I would like to conclude with the prayer for my side.
Thank you.
Therefore, in the light of issues raised, arguments advanced and authority stated, we humbly pray before this court in order to dismiss the petition and to pass in an order of notice, as this honorable court may deem fit and proper in the interest of justice and good conscience.
So this is a sign under section 152 because this is something which we are not used to before.
Your Lordship, if I may answer to the sign question as well. Your Lordship, the sign is just the means in which the 152 can be done, Your Lordship. Not every sign is prosecuted under 152. Only if that sign conveys separate tendencies. Indeed, Your Lordship. It was not an opinion before this question.
Council seeks permission to begin with the department. Much obliged. Your Honor, to begin with, the council seeks to highlight that my learned opinion co-councils have placed a heavy emphasis on law reports and conventions. The council would like to highlight firstly one of the arguments lies in the UN conventions against cyber terrorism. Your Honor, it is humbly submitted that India is not a signatory to this convention, and additionally, what the most astonishing to the council here is that in 2025 October, 72 nations signed this convention and India refused. And the observations made regarding this refusal were very imperative. First was the India raised concerns regarding data sovereignty, user privacy. Indeed, Your Honor, the council concludes that all these conventions and laws are pari materia and the same may be allowed to be argued. Much obliged, Your Honor. India is concerned about data privacy, user sovereignty, and lastly, most important, the lack of alignment with India's domestic laws. So this convention that they seek to argue under is not in consonance with the domestic laws, and domestic laws will obviously be given more regard. Further, as per the law reports, Your Honor, to answer the Honorable Bench's question, the norms of journalistic conduct are indeed not enforceable or justifiable. They are mere ethical guidelines that a person must comply with. And further, Your Honor, the council would like to contend that the petitioner's data is presumed to be legitimate and verified. First of all, if the state is contending that these are illegitimate and wrong and misinformation, they must discharge the burden of proving the same. Further, Your Honor, if the bench deems fit, the petitioners are humbly open to any assessment and verification to be carried out, which the bench may direct. Further, Your Honor, the council would like to highlight in regard to constitutionality. The constitutionality of Section 52 is currently being argued under a pending petition in the Supreme Court, and that alone is a major argument why the provision must be questioned and not allowed blanketly. Further, Your Honor, the council has not made any claim for mental health argument that he should not be prosecuted because he is in a mental health situation or there is mental distress. The council is arguing that he should not be prosecuted simply because the provisions are not, the ingredients of the provisions are not invoked. Further, Your Honor, the council humbly places before the honorable bench the case of S. Rangarajan versus P. Jagvijan Ram. Your Honors may find it on flag number 21. It was explicitly held that any political dissent, no matter how strongly worded, lands within the protective ambit speech. So, Your Honors, even if the petitioner is making bold claims which the council is agreeing to, the petitioner is claiming that it was the political media deployed. It's a very strongly worded allegation, and the same is held to be protected within the political dissent and expression speech. Further, Your Honors, the norms of journalistic expression, journalistic conduct, which my opponent co-counsel have relied on. Firstly, these norms are not enforceable, but arguing upon the same line, argument that the bench deems fit to give cognizance to these conducts, this report, the council humbly presents that the petitioner is an investigative journalist. The elements of investigative journalism are as follows. Firstly, things published must be of importance to the reader. Secondly, that the things which are published, against that there must be an attempt to hide those things and hide the truth of the reality. Your Honors, it is a job of an investigative journalist to highlight these uncomfortable truths even if they are against the government. Further, Your Honors, the council only submits that there is a big difference between state and the government. State is the master, the government is the machinery through which the will of the state is served. The right to criticize the government is protected, and the council submits that all the accusations made by the petitioner are a very bold accusation towards the government, and no sovereignty of the state is being questioned. Your Honor, the government is not sovereign. The government is merely a servant of the state. And the policies of the government, the actions of the government are open to political discourse, which the petitioner is humbly engaging in. Further, Your Honors, we have never questioned the intent of the state why the state is doing the activities. The petitioner rests a lot of faith in the state to act fairly. Further, Your Honors, as to the point made by my learned opponent counsel regarding damage to property and apprehension of public damage to public property. Your Honor, first of all, the council seeks to highlight the fact that the protest is reported to be peaceful. There has been no reports of violence, and no property damage has been done. And even upon the apprehension, if the state seeks to arrest the petitioner on the charges of apprehension of damage to public property, the same was never done. If the petitioner has announced that I will publicly self-immolate, then there is an apprehension, but that arrest was not made. So this argument cannot be entertained at this stage. Further, Your Honors, if the council may humbly refer to the statement made by my opponent counsel that we could have blocked the entire social media presence. Your Honors, is this an argument of how much of your right we could have curtailed? It is merely the fact that further, Your Honors, if I may add, the petitioner has been in custody for over a year now. He was arrested around 20th February, and it's been over a year and he's been in custody. So what good is this public access? What good is his social media devices not being seized because he already is in custody? He has no access. So is this an argument that they try to give as to we could have?
As a person similarly situated in India, we released.
Much pleasure. The council is not aware at the moment. Council shall definitely get into it after. Much pleasure. Further, if the council, as was beautifully highlighted by the Honorable Bench, Your Honors, the drone footages and the photos which were shared were not during an ongoing operation but afterwards. Next, the next argument that the council seeks to rebut in the court is that, Your Honor, section 66F firstly deals with the part B that they seek to invoke, deals with penetration, access, and access without authorization or exceeding that authorization. And this should be likely to cause violence or incite public disorder. Your Honor, the council acknowledges the fact that the state can invoke this upon apprehension of public disorder, but they still have to prove the means of this conduct which will cause that public disorder. What is the access of, what is the unauthorized access? What is the penetration? They have clearly failed to establish that. Further, Your Honors, the entire argument upon the drone footage matter is based on the fact that it was a restricted zone. Your Honors, that area, while the operation is ongoing, it is a sensitive area and the same was never released. After the operation ceases to exist, that is still a local area where people are residing, and instead of reporting a military cantonment, what the tribals are doing is they are making a video of where they live, that this is happening to our homes, and sharing with the local journalists who will raise awareness about the same. Further, Your Honors, the respondents seek to invoke drone rules which were issued under the Aircraft Act. Aircraft Act. Your Honors, Aircraft Act is the parent legislation, and these were the drone rules were the subsidiary rules. Your Honors, the respondents are making a very convenient interpretation of the laws. They are invoking Section 72 from the IT Act, then they're invoking drone rules from the Aircraft Act. So this feels like a very convenient interpretation of the entire law. In a way that whatever interpretation we may make, we just somehow want to prove the guilt of the petitioner. That may not be allowed. Further, the council only contends that the council seeks to clarify that the drone footage was not captured. The drone footage was not. The drone was not flown by the petitioner. It was done by the tribal leader. And if at all the bench finds that this capturing was illegal, this must be initiated against the tribal leader and not the petitioner. And this initiating of proceedings shall be done in a different FIR and a different trial altogether. So it is rather not a point of contention at presently. And if the honors have no counter questions, the council. Much obliged.
Your Lordship has been measuring all the rebuttals proposed by the opposition party. Your Lordship, starting with the rebuttal with respect to section 142, they have clearly calculated that we place heavy lanes upon the law commission report and judicial pronouncement. Your Lordship. They fail to notice that they have also laid on Barcode area versus state judgment. Your Lordship. In that judgment, it clearly talks about railway services safeguarding of nation security rules. Your Lordship. So it clearly interpreted the word subversive in the context of national security, also placing lanes on such a judgment, which is critical in this context, we have argued for 152. Also, in the context of 152, they have laid on the case of Rangarajan versus Zedjivan in order to say that political dissent and political criticism should not be prosecuted for your Lordship. Your Lordship, we agree to the same aspect, your Lordship. It is also provided in the explanation clause that political approbation denotes extreme dissent, your Lordship. Even extreme dissent is permissible under this act. But what is the tendency of your comment? It can lead to a separatist activity. It can lead to anti-national activity. Only for such an effect and tendency, we are prosecuting them under section 150. So this concludes for 150. They also made reference to the UN Convention against cyber crimes. We did not rely on the same during the course of arguments, but it is also persuasive in this court of law. It is true that India is not yet signed that convention, but the signature is opened till the end of 2022. So still there is scope for India to sign for the same, and it is also one of the universally accepted practices because it derives its origin from the Budapest Convention of the EU, which is regarded as one of the most developed developed analysis of cyber crime. So this is with regard to the UN Convention of Cyber. Thirdly, they have criticized the entire course and our reliance on the ethical guidelines. We still rely on our argument that the reliance upon guidelines is only for persuasive arguments. We are not saying that the breach of guidelines is constituting the offense. We are saying that he has breached the guidelines, but the content of the image and the content of the video is leading to the offense. It is breaching confidentiality. It is done without getting authorization. Only on those premises, this investigation and prosecution is being done. Only for mere persuasive value, and in order to identify what is the duty, what is the threshold that they should live up to, only for in reference to the same, we have relied on the guidelines. With respect to they have also stated the definition of investigative journalist and how they will be covered under the IT Act or not. As I have already argued a lot, in IT Rules 2021, it clearly talks about publisher of news and content. It did not name anyone. Even the definition says it can be of any name. Even it can be a podcaster who gives news information. And with respect to the question with regard to the 152 must be aimed against the state and not the government. Your Lordship, in this case as well, they have made dissent against how the government operates. They have criticized how the healthcare in the region is and how the government operates in general. We are not prosecuting for the same. They have the liberty to do so. Even Ashwini Upadhyaya case, for criticizing the caste discrimination in the administration in UP, he was first prosecuted, but the court said such a prosecution is wrong here. So they have the complete freedom to argue about the government. But here it is the case of separatism. It is the case of anti-nationalism here. If I may make reference to page number, paragraph number 11, it clearly states that there is claim for tribal autonomy. They are trying to ask the right of self-determination for themselves. Similar incidents can be seen in Khalistan and all the movements where there was a claim from the indigenous people itself. So that claim is also but they have also made reference that we suggested blocking of the entire social media platforms. Your Lordship, that is clearly misunderstood. I made reference to blocking of entire social media just which was observed in Anuradha Basin case. It was not the submission on behalf of the respondents. It was just in order to draw a parallel between Anuradha Basin case, which is highly relevant, and the present case. Finally, Your Lordship, they also finally put forth an argument that after the ceasing of the operation, the restrictive operation don't cease to exist, then how was the information confidential? We have already emphasized that information with regard to tactics, ammunition, inventory can be revealed to foreign enemies. We are also placing claims on the guidelines which is issued by the Ministry of Defence during the operations in the river. It issued 4 guidelines. First, towards general in nature. It clearly said you should not reach out to the members of the armed forces in order to interview them. You should not reveal the personal details and address of the armed forces. The third and fourth are highly relevant to the present case. You should cover only operational and procedural content of the operation. Final one, when active operation is going on, you should not cover the same. It also said until notified by the government or for a date of for a number of 14 days, you should not release any footage or you should not release any photos. In this present case, immediately after the incident, it will clearly reveal the strategies of the Indian army and it will pose huge threat to the national security. With this, I would like to conclude the part of the respondents. I would like to close the case. It was an honor of being with us.
This brings us to the end of the oral arguments. Thank you, participants. It was truly a delight watching you all today. I now request the judges to give their valuable feedback to the participants. It was truly an honor for HPNLU and the participants to have these judges.
Well, all of you, we must say, we have found you to be exceptionally intelligent, exceptionally good. And irrespective of the final result, I must confess that you are so much ahead of us as compared to us when we were abroad. Candid and very, very obviously true. Well, the first time I participated in a moot court contest was in the year 1990, when I was a student of this Himachal Pradesh University, and we went to this National Law College, Bangalore. So that was my first brush with what good moot court contests can be. But I must say that the standards are totally different. You are much, much better than many of the lawyers practicing. And I'm not flattering. Let me be very clear. I'm not flattering any of you. You see, I think my brothers will agree with me, and even the senior counsel will agree that you are much better than maybe 70 to 80% of the lawyers who are practicing. But don't take it to your head. Actual practice is a totally different ballgame altogether. Here you will not come across all these people. You come across someone. These my 40 days are not complete. Someone has close to my 2 this one of time. So prepositions there are totally different. But they say that if the first step has been taken, first step is a good step, and obviously you will reach and achieve what your dreams are and what you aspire. As far as I'm concerned, I will say a big compliment.
As my brother stated, you all were excellent. It's not a question of winning or losing. Team of Petitioner or Respondent may win, but all of you are excellent.